Before we proceed, I just want to confirm with counsel, legal representatives here in court, that I've informed you that this court won't be sitting on coming Friday, that is the 9th of May, because of commitments I have elsewhere. But then we will probably adjourn at about 1 o'clock on Thursday the 8th of May to comply with the request by counsel that at the end of the week we adjourn at about 1 o'clock so that counsel have enough time to travel back home. But then I also informed counsel that this court won't be sitting on 14 and 15 May because of a civil part heard matter in which I'm involved. But that situation has now changed. On Friday, I received a notice of removal from the role by the parties in that matter. So we will be able to proceed with this case on 14 and 15 May. If any counsel have made other arrangements for 14 and 15 May, they must please inform me now so that I know where we stand.
My Lord, I've accepted a bail application in Johannesburg. But there is still time, so I'm sure those instructing me can make alternative.
Thank you.
I have a similar issue, but I'll resolve it.
Is it also a bail issue,
No,
Mr.?
I had matters that I put in as stoppers and I told them that you're not sitting.
Yeah, I'm so sorry. This is out of my hands. But please see to gentlemen what you can do about it, and if you can't get out of it, just inform me. Thank you. Mr. Denason?
As it is reported, there is the issue of Mr. Paper. I understand that it was discussed with him.
Yes.
He is in the United States. Luckily, it's not an extradition issue.
Yes, I understand that his daughter is graduating in the USA, and he called to ask permission to be excused today and tomorrow, if I'm not mistaken.
I think he's coming back on Wednesday.
It doesn't matter, but I granted the permission.
Yes.
Thank you.
Returning to the leading of evidence in the trial within a trial, my colleague will handle that part. If it's so pleasing the court.
Thank you.
Well, there's also one other issue I'd like to
Yes, sir.
Lord, insofar as Mr. Zulu's plea is concerned, we had initially submitted that the jurisdictional issue could be cured during the course of the evidence in the trial. But upon revisiting the issue, my submission is that it's something that has to be resolved before any of the evidence on the merits is led. And that's because of the implications of Section 110. Because the remedy is not that there is a verdict, but if this court doesn't have the necessary jurisdiction, those charges must be transferred to the court that has that jurisdiction. So I'm not sure if it would be expedient for us to continue with accused number 17 and then thereafter we'll deal with
Yes, I was going to suggest that.
Thank you, Mother.
Thank you.
My Lord, we sent an email to the state on Friday and only received the court secretary's email on Sunday. We wished to supplement the state's bundle with some of the missing documents for the trial within a trial.
Yes, I was informed by my secretary that she received in excess of 200 pages documents last night just before 8. And she only informed me of that this morning, but even if she had informed me last night just before 8, I wouldn't even bothered to look at it.
Yes, my lord.
So what I suggest is, as we proceed with the trial within a trial, you may present whatever documents become relevant during the course of the trial within a trial.
Thank you, my lord.
Thank you.
We've printed some for the court, so we'll hand
Yes.
as and when.
Yes. So who is appearing for the state then?
I confirm my appearance, my lord.
Ms. McPherson.
We may then, if all parties are ready, that we proceed to call the first state witness with regards to the trial within the trial, Benjamin Friedemann Carlitz.
I want to remind the media, please, I've conveyed my decision to you earlier that I do not want photographs or any footage taken of witnesses in the witness stand. Thank you.
Your full names and surname, please.
Benjamin Friedemann Carlitz.
Do you have any objection to taking the oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please write. Say so help me God.
So help me God.
Thank you. You may be seated.
Two.
Did you say your surname was Carlitz?
Carlitz. Carlitz.
Carlitz.
Carlitz. C-A-R-I-T-Z.
Thank you.
Thank you, my lord. My lord, just with regards to housekeeping in terms of language, is it all right that we proceed in English for all of the accused persons as well?
Are there any of the accused who would like the evidence of this witness to be interpreted into another language like Sotho or Xhosa or whatever? Nobody? Thank you.
Thank you, my lord. For record purposes, please will you state your highest level of education?
That will be grade 12.
Where are you currently employed?
With the Directorate of Public Prosecutions, Serious Corruption, Priority Crime Investigations, Serious Corruption Investigation.
What rank do you hold?
I'm a captain.
For how long have you been a captain?
5.5 years.
For how long have you been stationed with the Serious Commercial Investigative Unit?
That also will be 5.5 years.
Prior to that,
Just a moment, please.
my apologies, my lord.
Captain, you must just be mindful of the fact that I have to record what you are testifying. So if you go too fast, we're going to lose some of what you are saying. You are in the Senior Investigation Unit of?
Serious Corruption Investigation Unit.
Is that of the police?
That's part of the Hawks, Directorate for Priority Crime Investigation.
Thank you.
Prior to be stationed with the Serious Corruption Investigative Unit, where were you stationed?
I was stationed at Park Road Police Station, fraud unit, for approximately 25 years.
Is it correct to say that you are currently the investigating officer of Park Road Mass 48602 of 2020?
Yes, I am.
Is it this case?
That's correct.
With regards to investigations of a nature such as the one we are before court today, are you able to estimate how many types of investigations of this nature you've done?
Well, I've done, I can't say the precise amount, but as I said, I've been involved in fraud and corruption for the last 30 years. To put an exact total on it, that will be quite difficult.
Would you be able to estimate in terms of single digits, double digits, perhaps hundreds?
Well, if you talk about corruption alone, that will be around about, say, 5 to 10 cases. Fraud itself, well, there it will be hundreds. Where the charge is simply fraud, it will be hundreds, but as I say, corruption, 5 to 10 cases.
Prior the matter formally registered as a docket, was it prior to that an inquiry?
Yes, it was.
Did you have knowledge of the inquiry?
Well, the inquiry was booked out to me, or was allocated to me by my commander when it arrived at our unit. So I was the first investigator of the specific case.
The knowledge of the case in itself, seeing as though you were there from the inception of the inquiry, how would you describe your knowledge of the case itself?
Well, I have knowledge of the whole case. There might be some aspects where I need to remind me of some aspects because we talk about 5-6 years has passed since the beginning stages, but I have knowledge, broad knowledge of everything.
Now, Captain, you called here specifically with regards to an issue relating to jurisdiction. Are you aware of that?
Yes, I am.
Specifically with regards to accused number 17, Cholota.
That's correct.
When did you first become aware of Cholota's involvement in the matter?
Well, obviously I can't mention a specific time and date, but there were a lot of people of interest in the investigation. So from the beginning we knew about her. It only became relevant later on when certain other information was obtained, direct involvement in this matter. So I should say, if you wanted a specific time, I would say around about 2020, approximately.
When you say that there was then direct information and evidence linking to Cholota, what are you referring to?
Well, later during the investigation, we got a hold of certain electronic devices with emails on it relating to correspondence that Ms. Cholota was responsible for between out of the office of the Premier of that time, as well as certain contractors and service providers relating to this asbestos matter. As well as documentation obtained from the department itself.
These electronic devices, whose were they?
It was a laptop, her own laptop that she used at the Premier's office during a period that she was employed there.
Were there further electronic devices?
From her itself, not to say from her, it's the laptop, and we did some downloading of other service of the Department of Human Settlement itself and of the Premier.
It's also correct that at a later stage you embarked on a trip to the United States of America during September 2021.
That is correct.
Just
What-
repeat those dates again.
During September 2021, my lord. Why was there a decision to travel to the United States of America?
Well, we had discussions with my prosecutor, Peter Mason, and it was decided by him that we should further investigate and have an interview with Ms. Cholota relating to these documentation that we obtained through the investigation to get certain clarities on those.
When you speak of we, who is that we?
That would be my provincial commander at that time. During that time he was Brigadier Gerber, currently he's General Gerber. Me and him went over to America during that period.
And Advocate Mason of the National Prosecuting Authority, where was he at the time when you went overseas?
Well, in Bloemfontein.
There was an interview that then took place on the 22nd of September 2021.
Yes, that is correct.
Can you explain to us the events of the date of the 22nd of September 2021 from the first time you then had sight of Maid Cholota on that day?
We had the assistance of the FBI, specifically Special Agent Denise Bean. We drove where Q17 Ms. Cholota was residing in Baltimore.
Did you say Baltimore?
Baltimore, Maryland. Yes.
Please proceed, Captain.
We drove in two sedans, myself, now General Gerber, and this Special Agent Bean drove in one vehicle, and there were other agents in another vehicle where we drove to the residing premises.
Can you please describe these sedans to us?
Well, the one we drove in was a Ford Taurus sedan. I do not know the make of the other sedan.
Can you recall what color they were?
The one we drove in, I think it was like a gold color. other one was also light in color, but I can't recall the exact precise color of that.
And can you recall what the windows were like of these particular sedans?
No, it was clear. It wasn't tinted or anything like that. It was a normal vehicle, like a normal vehicle of the public. There's no indication that it was an official vehicle.
You then drove in these unmarked vehicles to the residence of Moroadi Cholota. What then transpired?
Well, when we arrived there, our car where we were in, we stopped way back, but we had sight of the flat where she was staying. Me and General Gerber remained in the vehicle.
Please proceed, Captain.
Special Agent Bean then accompanied her other colleagues, also from the FBI, to the front door of the premises. We were in sight of the flat, but we couldn't hear what was said during the discussions when eventually they knocked and the door was opened.
Yes, Captain.
Well, they went inside, and when they all came out, Ms. Cholota climbed into her vehicle. If I recall, it was a Lexus SUV, light in color, I think like white pearl color. She drove in her car. She wasn't accompanied by any of the agents, or myself, or General Gerber. And then we took her to a hotel that was pre-arranged by the FBI and Special Agent B for the interview.
This interview that took place, who was present during the interview?
It will be myself, General Gerber, Agent Bean, and then Ms. Cholota.
Can you explain to us how the interview itself unfolded?
Well, we introduced ourselves to Ms. Cholota, identifying who I am, who General Gerber is, what is the purpose of the interview, why we were there. And then we also told her the fact that, according to correspondence, she was a state witness, and we had to clarify certain aspects and documentation that we obtained during the investigation.
How long did this interview take place?
Approximately 3 hours.
Was there a specific reason why this interview came to a halt on the 22nd?
Well, we had a lot of questions for Ms. Cholota, as I mentioned. But at the end, we stopped the interview. Ms. Cholota had a request that she had a previous engagement with classes at the university, Bay Atlantic University, where she was studying. So we accommodated her, and it was around about 12 o'clock, if I recall. We stopped the interview to give her time to get to her classes in Washington, where the university was situated.
During the process of the interview, did Ms. Cholota have contact with any other individuals?
Yes, she also requested if she can see what you mentioned, her boyfriend, who she was staying with at the residence where she was first contacted. So he arrived at the later stage during the interview, and we once again had a break where she had certain discussions, of which I do not know what, with him. But then we continued afterwards.
With regards to the questions that you were posing to her, was she helpful?
No, she was not.
Were there any specific tactics that you'd utilized during this interview process?
Well, that could be a bit of a broad question. But if I can just explain, when the interview starts, we will make obviously the person comfortable explaining why we are there. Ask general questions from where are you, all those stuff, just to get a person calm. And then we'll get to the real questions that we need answers to or clarity on.
At that particular period of the 22nd of September 2021, you'd indicated that you were interviewing her as a witness. Is that
That is
correct?
correct.
Are you aware, if she had been aware of the fact that she was possibly going to be called as a witness to the state?
Yes, she was. There were various correspondence between herself and Advocate Nason and General Gerber. Me, myself, never spoke to her via email or anything.
When you were conducting the interviews, was there any legal representative of Ms. Cholota at that stage?
No, they weren't. If we talk about Thursday,
Did Mayor Cholota make any mention of a legal representative on the first day?
That was only just before we closed the interview for the day.
In what light did she make mention of a legal representative?
If I can just clarify that, the request for legal representative wasn't made by her. During our questioning of Ms. Cholota, it became apparent that she didn't want to answer questions directly relating to the documentation that we presented to her, like the emails that she was the author of.
Please continue, Captain.
During some of the questions in the emails, there were mention made who gave instruction on the request that she send the emails on. And we wanted clarity on who specific she said gave her these instructions. Although the emails mentioned the Premier, we want to know who she talks about as the Premier. She kept on saying that it is the office of the Premier. She didn't want to specifically put a person's name to the wording. Other questions that we put to her relating to involvement of with the contractors and other people, other possible suspects, she would answer she doesn't know the relevance of this question. She doesn't want to answer because she doesn't understand what is the relevance. So that was the trend, that was the questioning about and the answering of those questions.
Yes, Captain.
For a witness, for us, that was a bit strange. A person who gave the indication that she will give a full cooperation with any answers or clarity we wanted. So we reached a stage where I actually informed her that I think it would be best that she would contact a legal representative, and that if she does not start answering questions honestly and directly, we might change the interview, that she might be considered as a suspect. Due to the fact that the emails implicated her already, and that is why we gave her the advice to speak to a legal representative during the evening, as we already made an arrangement for a next interview the next day in Washington.
You had given her the advice to seek legal representation. What then transpired next, still on the 22nd of September 2021?
Well, after we went our way, she climbed in her car and drove away. Me and General Gerber had a discussion, and later that day we also contacted Advocate Ace, our prosecutor, to give him feedback on what transpired on this specific day during the questioning.
At that particular stage, what was Ms. Cholota in your view? Was she still then a witness, or was she potentially a suspect?
Well, at that stage she was still a witness.
And these particular discussions emanating from what had transpired during the interview, what were those discussions?
We're talking about with Advocate Ace
And General Gerber.
and General Gerber. Well, we discussed what transpired during the day, unwillingness to answer questions directly, to give clarity on certain aspects, and then it was decided after the discussion with us three, between our three, that we will see what transpired the next day during the next session of questioning, where we will put the same questions to her to get clarity and see what is her demeanor that day. And if it is the same as the previous day, well, then we will take the decision to change her from a witness to officially warn her as a suspect, possible suspect.
The day of the 23rd of September 2021 arrives. How on that day did you meet up with Mayor Cholota?
By that time we were back in Washington, so we made an arrangement that we will pick her up at the train station in Washington that morning. I think it was around about 9 o'clock. And then she drove with us to the embassy, South African embassy in Washington.
Again, when you speak of us, who is the us?
That will be myself, General Gerber, and
Did she arrive, Mayor Cholota arrive alone at the train station, or was she with anyone?
well, yes, according to me she was alone.
The previous day of the 22nd of September, you indicated you advised her with regards to legal representation. Was this aspect discussed on the 23rd of September?
Yeah, that was discussed, but only when we arrived at the embassy, where arrangements was made. We will consult with the news.
We say arrangements or discussions took place at the embassy,
South African embassy.
South African embassy. What discussions in relation to legal
The
representation?
questioning, if I can say.
Yeah.
We continued with the questioning like the previous day.
Without legal representation.
Well, at that stage, yes, because we still considered her as a witness.
Are you aware as to whether or not she had discussed anything with her legal representatives the evening of the 22nd?
No, when we started the interview again at the embassy, we asked her. She said she didn't contact any legal representative.
You then continued with your ordinary line of investigations on the 23rd of September.
That is correct.
What then transpired in the interviews with her on the 23rd?
Well, it was similar as the previous day. She still did not change her mind in answering questions directly or giving direct explanations on these documents or other questions we had. So at the end, me and General Gerber had a discussion that, as we discussed the previous evening with Extradition,
Yes. Yes, Captain. As the discussions per the previous evening.
yeah, so when she didn't give her cooperation, then we went over to officially inform her that she is no longer to be considered as a witness, but she will be treated as a suspect from there.
Can I just get clarity on this point, Captain? On the 23rd, you interviewed her again, and there was still no direct replies or any clarifications that satisfied you. Did you then again speak on the 23rd with Advocate Donation?
Not at that stage. We did, but only later after all the proceedings on the 23rd was finalized.
Yes, but when did you finally make up your mind that she would be a suspect from now on?
That will be during the discussions and the interview held at the embassy.
No. At that particular point then, it was a decision that had been made as per prior discussions. However, it was a decision made by yourself and General Gerber, if I understand you correctly.
Yes, the discussion of the previous evening was that we have to use our own discretion of whether she's going to remain a witness, giving her cooperation or not. So that decision was made by myself and General Gerber after we discussed it.
You then took the decision that should formally be charged as a suspect. Please walk us through that process.
If I can say before we got to that, Ms. Cholota requested at that stage that she wants legal representation.
Was that the first point where Maid Cholota had requested legal representation?
Yes, from her side.
What did you then do about this request?
General Gerber, we stopped the interview, and General Gerber went to find out if there was any legal person present at the embassy.
What then transpired, Captain?
There weren't any legal representative or legal person present at the embassy at that stage. So we continued with taking the warning statement of the suspect.
What does that entail?
If I can just explain the warning statement. It's basically a statement, it's in two parts. The first part is a statement by myself as the investigating officer where you officially inform the person in question, the suspect, of the rights according to the Constitution, such as remain silent and have a legal representative present, as well as other questions like were you assaulted or threatened, are you sober. There's various questions relating to my part of the affidavit.
That is then the first part of the statement. What is then the second part?
If I may just mention on the first part, I didn't mention that is also where the charges, alleged charges, will be placed before her.
Yes, sir. Captain, my apologies. The second part.
The second part of the affidavit is where she will give her affidavit as to explaining the circumstances. But because of the fact that she did not have a legal representative present and we could not find one to assist her, we did complete the affidavit as per the personal details of Ms. Cholota. But from there on, we stopped asking any questions relating to the facts in the investigation due to the fact that she didn't have any legal representation present to give her guidance and assistance.
Did she, of her own, volunteer to give any information in this regard?
Are we talking about the personal information?
With regards to the entire warning statement, were there any undertakings made?
Well, Part of the undertaking was that she will provide us with an affidavit from her side after she's spoken to her legal representative.
To the best of your knowledge, was this done?
We never received such an affidavit as mentioned on the warning statement.
The events of the 23rd of September 2021, how long was May Cholota with you?
That was also about 3 hours.
And upon the conclusion of that interview, as well as the taking of the warning statement, how did May Cholota leave the embassy?
Well, we approached the ambassador at that stage to thank her for assistance, and then there was a request from Ms. Cholota if she can take a picture with the ambassador. So we went outside and pictures were taken.
Were you present at the time those pictures were taken?
Yes, I was. There were pictures of myself, General Gerber, and the ambassador. There were also pictures where she is alone with the ambassador, and a colonel was stationed at the embassy who's working there.
If leave of the court, if I may provide the same to the witness to confirm that this is a particular picture he is referring to.
Yes, this will be the one.
There had already been a copy provided to my learned colleague, however, it was in black and white. This is just a colour copy. The same have also been attached to the bundle that are previously before the court. However, if we may supplement that there is in fact a colour copy of the photograph.
Are you referring to Exhibit 9?
Indeed, sir, my lord.
That photograph?
That
is in
photograph,
Exhibit 9.
my lord, if we may then hand it into court that we have a colour photocopy, as in the bundle of the exhibits, it is merely a black and white copy.
Where do I find that black
My
and
lord,
white?
if I may, just 1 second. My lord, I believe it is attached with regards to HI. I may just confirm the page numbers to be aware of. My apology and thank you for the court's indulgence. My apologies, my lord, it's JK. And it is referenced AA3. And it is a very indistinct black and white copy, My Lord, perhaps if I may,
Is there a page number?
unfortunately not, my Lord, if I may request that I have the exhibit handed down to me, that I may page to the correct page for the court to make it quicker.
Thank you, Captain. Who is the lady in the middle of this photograph? Is that the ambassador?
That is the ambassador.
And the gentleman on the left?
That's a colonel stationed at the embassy, like an attaché or something.
You confirm you were present when this photo was taken?
Yes.
All right, so the photos then were then taken outside the embassy. What then transpired?
Well, after the photos were taken, we took Ms. Cholota to the university in Washington. We dropped her off at the Bay Atlantic University.
At this juncture, despite having taken the warning statement, Ms. Cholota was still free on her own volition to go back to the university.
Yes.
And in fact, you were her transport back to the university.
Yes, we were.
You've mentioned the fact that Ms. Cholota on the 22nd of September had wanted to speak to her boyfriend at times during the interview. Was there any similar arrangement on the 23rd of September?
No, they weren't.
It would appear that there were a few requests from Ms. Cholota during this time period, for instance, to be excused earlier to get back to the university, to be able to consult with a boyfriend, potentially to have spoken to a legal representative. Did you adhere to all these requests?
Yes, we did.
If we look at the period of the 22nd as well as the 23rd of September 2021, what was the period that you were actually physically involved in the interviewing of Ms. Cholota?
But as I said, it was about 3 hours the first day, on the 22nd, and 3 hours the second day. There were a few interruptions, as I mentioned. I can't say exactly how long these interruptions were, but some of them was on her request, and then once or twice we took a break just to have a discussion between myself and General Tabit.
In any event, on the 22nd of September, Ms. Cholota went off to the university without your custody.
Yes.
And during the interview process itself, what was her demeanor like?
Well, she became, in the beginning it was a friendly demeanor. We had the discussions, but as we went on it became more aggressive, answering questions, didn't want to answer, didn't like the questions that were asked. It was, if I can say, for us we got the intention, she did speak to someone and she was evading and avoiding certain aspects.
It is a main contention of Mayor Cholota that the only reasoning for her being charged was her failure to formally implicate her previous boss.
No, that is not correct.
How can you say so?
The questions was of a general nature of who she knows, as I mentioned before, contractors. Do you know this contractor? What's your relation? The question relating to a previous boss, the Premier, that was straightforward as the emails indicated.
And furthermore, that the charges were only then laid against her in that you were following through with a threat if she did not give her cooperation.
Well, we don't say it's a threat. It's a bit of good advice.
And in your own, what would that bit of good advice actually be? What did you inform her?
Well, that she should speak to a legal representative on her own accord and explain what was transpiring so that she could get advice from this person to say whether give your cooperation or don't give your cooperation.
And with regards to her giving of cooperation, was there any advice given regarding that?
No, only the fact that it would be in her own benefit if she approached a legal representative.
It was also indicated that there had been threats placed on Mayor Cholota by yourself and General Gerber. What do you have to say to that?
We don't threaten a person because the final decision isn't made by us. There's no purpose in threatening a person. The final decision to prosecute is made by the prosecutor after all the evidence is compiled. We do not make that decision, so there's no purpose in us threatening. Either a person works with us or the person works against us. It's that person's decision.
Are you aware of any charges leveled against either yourself or General Gerber with regards to threats?
There was, I think it was in the High Court, Ms. Cholota lodged complaints against myself about these threats. I don't think there were charges against General Gerber. It was only against me, the Minister of Police, and I think the Minister of Justice.
Were there any criminal charges
No.
leveled against?
No criminal charges.
Where were these complaints lodged?
Here in South Africa. In Bloemfontein.
You mentioned something about the High Court.
It's applications that she did regarding the expedition itself, and I was mentioned as one of them.
Perhaps you then had made the decision, the warning statement had been taken, the photos had been taken, Mayor Cholota had then left. At what point thereafter did you speak to Advocate Mason?
Well, it was, again, I can't say when, but it was on the 23rd. Because of the time period delay, it was during the 23rd we spoke to him.
For clarity, was this during your decision making, before your decision making of the 23rd, or after the decision
No, that
making?
was after when she already left and we arrived at the hotel, back at the hotel where we were staying.
And you then confirmed that you then informed him what transpired?
Yes, we did.
It is also correct that there were never any formal charges placed against you. It was merely a civil application brought
That
by
is
Mayor
correct.
Cholota.
That is correct.
Captain, to be direct, did you threaten her in any manner?
No, we did not.
Would you say that your conducting of the interviewing with her as a witness was in line of how you conduct other witness interviews or not?
Yes, it is.
And at the point where she was then deemed to be a suspect, did your manner of dealing with her change?
No, we did not.
Would you indicate whether or not there was any intimidation leveled against her to speak to you?
No, we didn't intimidate. No, no, we did not. Not intimidate, not threaten, nothing.
Would you be able to indicate whether or not you would deem it that you treated her in a cordial fashion or a good fashion?
Yes, actually with respect, if I can say it like that.
Captain, prior to even going to the United States of America, was there evidence that implicated Mate Cholota?
Yes, there definitely was. And that was the original purpose of going over, to clarify these things.
What evidence would you indicate that there had been?
Well, the communication, as I mentioned, the emails, the communication between Ms. Cholota and the contractors involved in this asbestos matter, requesting money for bursaries, school fees, purchasing of laptops. Those requests were all made by her, but on instruction of the Premier, as indicated in the emails.
What was the purpose then looking at her as a witness initially and not as a suspect?
Well, she gave an explanation on who gave the instruction for these requests. That wouldn't have been a problem, but mere the fact that she didn't want to put her name to the email itself, it made her a suspect and complicit in the commissioning of the crimes.
The investigations that you have conducted into this particular matter, if we can call it the asbestos matter, there are also allegations in terms of the State Capture Report or Zonda Commission. Can you explain how your investigations were conducted?
Well, as I said, I started this investigation in October 2019. This investigation started based on a news article in the newspaper. Where the allegations of the asbestos removal was made. So that is where the investigation started. At that stage, it didn't have anything to do with the Zonda Commission, Public Protector, Specialized Investigation Unit, although I knew that they were also involved in this, in that, but criminal investigation and the investigation is two different things.
You had also previously indicated that there was communication with Mayor Cholota prior you going across to interview her.
That is correct.
Can you confirm who made that communication and what the means of the communication were?
There was communication between herself and Africa Denison, discussing the fact of her being a state witness. There was also discussions between herself and General Gerber relating to the same issues.
Can we then assume that it was not when you had started the interview on the 22nd of September 2021, it was not the first time she had believed she would be interviewed with regards to being a state witness?
That is correct.
Are you aware of any undertaking by Ms. Cholota to return of her own free volition to South Africa prior to extradition?
Yes, I am.
How are you aware of the same?
It was during one of the pre-trials. We after the discussions with Mr. Magashule, we addressed the judge stating that Ms. Cholota will come back to South Africa on her own accord.
Was that at the time when she was still a state witness? Was she then already a suspect?
She was then already considered to be a suspect, an accused, but not officially charged in South Africa.
And Captain, it's correct to say that you would have to have had her in the Republic of South Africa in order to have charged her.
Yes, officially.
There were also at a later stage further communications that also had confirmed her initial agreement to return to the Republic of South Africa to face charges.
Yes, they were.
There's also a trike that she then did not return, which resulted in the extradition process.
That is correct.
During your investigations, there had also then been an initial link to certain African countries. Is that correct?
That is correct.
If we may look at this as the Kenya-Nigeria debacle.
Yes, that is correct.
What did your investigations say?
Well, we pulled a movement control outside the borders of South Africa, where she travelled in all this. And we saw that a few times she traveled to Kenya. We later heard that it was actually Nigeria, but the problem is we can only follow up till a certain point because it's another country. So that is where our information stopped.
What was the relevance of this connection to the African countries?
Well, for us it showed that she had connections outside the borders of South Africa. Someone she knew at that stage, that was the only explanation we could have. We later on learned more, that her actual husband is staying in Nigeria. Let's say the father of a child, not say the husband, I do not know whether they're married. The father of the child as well as a child is staying in Nigeria. And Kenya was only like a connecting flight to Nigeria. But as I said, at that stage we couldn't follow up from Nigeria, from Kenya, where that went.
Did this have any impact on the actual merits or facts of evidence against Moroadi Cholota?
No, that had nothing to do with the actual facts or charges laid against her.
My Lord, I see it is already 3 minutes to 11. If we may proceed, I'm not sure if the court would like us to adjourn at this point. I'm going to start with regards to the handing in of the actual exhibits before court.
Yes, is the evidence in chief of this witness still going to be some time?
It may be so, my Lord.
In that case, I think let us stand down for half an hour. Court will now adjourn. All rise.
Sir, you still under oath to speak the truth? You may be seated.
Thank you, my lord. Captain, prior our adjournment, we had left off with regards to the aspect of the African country and as to whether or not there was an impact on the actual facts of the merits at hand. Do you remember that?
Yes, I do.
We are also aware of the fact that after Moroadi Cholota did not willingly return to South Africa, there were certain extradition processes that were followed.
That's good.
Captain, with regards to these extradition processes, were you involved with regards to the preparation of certain statements?
Yes, I was.
If I may pass the same to you to request if you identify the statement.
Yes,
Do you
it is
see the
my-
statement in front of you?
Yes, I do.
Do you recognize the same?
Yes, it is my affidavit.
Do you confirm that it is also your affidavit was then ultimately signed and commissioned on the 13th day of December 2021 at
Yeah.
11 a.m.
That is correct.
With leave of the court, if I may hand the same into the court for ease of convenience. Captain, I'm going to also request that you read this specific affidavit into record.
Is this affidavit contained in...
No, my lord. This, after we have passed muster, will request that it is marked as Exhibit 10 to the exhibits of the trial.
Yeah.
May we request copies of this document? We have the file, we don't, unless we can be directed to it in our file. But there's so many files it's impossible to carry them all to court. So if we can, we won't stop the proceedings now, but in due course, if we're going to read it out, we can be provided with a copy, we'd appreciate it.
My lord, we'll make copies for my learned colleague that has requested the same, as it is in any event only with relation to accused number 17 in this particular set of facts, as it's with regards to the extradition application and not any further. However, in the interim, if we may proceed with the proceedings, and during lunch we'll make the necessary copies to ensure that my learned colleague is supplied with the same.
Thank you.
We're indebted, thank you, madam.
You will proceed to read the same into record.
Thank you. Parker Cas 486/2/2020. Benjamin Veerman College states under oath in English. I am a captain in the South African Police Service with personal number 0431-262-7, attached to the Serious Corruption Investigation Unit, SCI, Directorate for Priority Crime Investigations, DPCI, with street address, Absel Building, Charlotte Makeke Street, CBD, Bloemfontein, postal address, private bag X20560, Bloemfontein, postal code 9300. Contact details 082-442-3635 and email address carletsb@saps.gov.za. The facts herein contained are within my personal knowledge, save otherwise stated or apparent from contents, and are to the best of my knowledge and believed to be the truth and correct. I am the investigating officer in Park Road, Parkwegkas 486/2/2020. The facts. In early 2014, the Gauteng Province, Republic of South Africa, RSA, contracted for asbestos eradication. The Gauteng contracts were awarded to 8 companies, one of which was Blackhead Consulting Pty Ltd, with registration number 2011/011-664/07. The Gauteng Province contracts ended in March 2014. Paragraph 4.2. On 28 May 2014, Mtumotsi Mugesi, the then head of department, HOD, for the Free State Department of Human Settlement, Free State Province, RSA, responsible for all housing-related matters in the Free State, received a proposal for the audit, handling of hazardous material, removal and disposal of asbestos-roofed houses. This proposal was submitted by a joint venture, Blackhead Diamond Hill Trading 71 Consulting JV. The JV was seeking to be awarded an asbestos eradication contract in the Free State. Notably, the Free State had yet to define an asbestos eradication project for public housing and had not requested submission or proposals. This proposal by the JV was unsolicited. Due to the fact that the Free State Department of Human Settlement did not have a submission or proposal for such a contract during the 2014-2015 financial year and had no budget for such a contract, the Free State Department of Human Settlement made use of South African Treasury Regulation 16A6.6, which reads as follows. The accounting officer or accounting authority may, on behalf of the department, constitutional institution, or public entity participate in any contract arranged by means of a competitive bidding process by any other organ of state, subject to the written approval of such organ of state and the relevant contractors. 4.6. During October 2014, a contract to the value of 255 million was awarded by the Free State Department of Human Settlement to the JV without following the prescribed tender process, but instead piggybacking on the Gauteng contract. The Auditor General, who oversees all the contracts awarded by the provincial departments, in his report dated 31st July 2015, indicated that the awarding of the aforementioned Free State Department of Human Settlement asbestos reference number 147 of 2019/2020, dated 20 March 2020. Various non-obligatory payments were made by persons or institutions of interest to and for the benefit of government officials and or their beneficiaries or dependents and or themselves, which creates a reasonable suspicion concerning the overall legitimacy of the Free State asbestos contract, especially with regards to the following issues and processes. The awarding of the agreement, especially with regard to the extreme terms and conditions thereof, the agreed contract amount and fee. These unjustified payments for the account of Diamond Hill Trading 71 with registration number 2012/100-469/07 and accused in this criminal matter, and the account of Mr. Ignatius Mkombani, the sole director of Diamond Hill Trading, not only corroborates suspicions in this regard, but also reflects a suspicion of suspected proceeds of unlawful activities. During the course of this investigation, evidence has shown that individuals associated with the fraud and corruption scheme would use contractors' business accounts to pay certain expenses directly after receiving funds from the Free State Department of Human Settlement contracts as a request of the Free State Premier's Office, of which Mr. Magashule, and accused in this criminal matter, was the Premier at that stage. These expenses directly or indirectly benefited Magashule and all persons or entities associated with him or served to ingratiate Magashule to his constituents. Interview with a suspect in the US. In accordance with the mutual legal assistance agreement between the South African government and the United States of America, Brigadier Gerber, Provincial Commander Serious Corruption Investigation Free State, and I, the investigating officer, on 22 September 2021 conducted an interview with Moroadi Cholota at the Sheraton Hotel, Maryland, Baltimore, USA. During the mentioned interview with the Moroadi Cholota, various questions were asked relating to emails sent by her on instruction of the Premier, Mr. Magashule. These emails relate to requests for payments to be made by the contractors who are registered service providers at provincial departments in the Free State. These requests would vary from student fees, laptops, and travel expenses. These emails relating to the interview will be discussed below. On 23 September 2021, a follow-up interview was held with Moroadi Cholota at the South African Embassy in Washington, D.C. During this interview, the same questions were asked as during the previous interview due to her unwillingness to answer these questions. On both occasions, Cholota indicated that she was not comfortable answering some of these questions, including who gave you the instruction to send these emails to the contractors asking for payment and assistance. Such questions were answered indirectly, even though the content of the aforementioned mails are obviously indicating that the requests were from the Premier, Mr. Magashule. When asked who gave the instruction, she kept on answering the office of the Premier. At no stage did she identify the instructor or the content of such emails, but rather referred to the office involved, as indicated above. The interview came to a point that it was clear that she is not willing to cooperate, as she previously indicated. During the second interview, Cholota requested the legal representative to be present. Such legal representative could unfortunately not be procured at that stage. Due to the available evidence as well as the hostility of Cholota during both these interviews, the decision was then made by the South African delegation to rather treat Cholota as a suspect rather than a state witness. Cholota was then informed by me that she is no longer considered as a state witness but as a suspect. Cholota was informed of all charges against her, whereafter right not say anything, and that she does provide any reply, such will be recorded in writing and might be used against her in a court of law. The right to have a legal representative present was also explained to her, which option was executed by her, as she indicated that she will first consult with the legal representative, whereafter she will respond in writing to the alleged offences. A warning statement capturing her rights and replies indicated was then obtained from her. After the donation, the dedicated prosecutor from the Office of the Director of Public Prosecutions, Free State South Africa, later confirmed the decision to add Cholota as an accused in this matter. Full particulars of this accused are as follows. Nomahlanga Moroadi Cholota, personal assistant to Mr. Magashule, passport number A085438558, date of birth 10 February 1987, cell phone +27 820 514 326, and US CPN number 443 360 7414. Email account moroadicholota@gmail.com. On 6 October 2021, an application for a warrant of arrest was successfully applied for Nomahlanga Moroadi Cholota with identity number 870210093485 and passport A085438558, currently residing at 6604 Northwood Court, Maryland, Baltimore, USA. Such arrest warrant was authorized by Senior Magistrate Mr. M.C. Mukhobu, Region 3, Free State. Involvement of the accused. Cholota was the personal assistant of Magashule in his position as the Premier of the Free State from 2009 to 2017. She was responsible for all functions normally associated with this post, including the scheduling of his diary, making of bookings, communicating with parties, insofar as being instructed by an employer, to the coordination of his appointments, etc. The current investigation, amongst others, confirmed that Cholota corresponded with some of the contractors who made direct payments to certain beneficiaries on behalf of Magashule. Email records were located on devices used by Cholota, confirmed unlawful instructions from the Premier to contractors to pay unjustified expenses such as travel and accommodation, study fees and equipment for students studying abroad, and donations to the African National Congress. It is alleged that Cholota had full knowledge of the contracts referred to and was therefore co-conspirator and complicit in arranging of misrepresentations to the Free State Department of Human Settlement and or Treasury, which caused prejudice to the amount of 230 million rand and additional potential prejudice of 25 million rand. The charges against Cholota: 8 charges of fraud, 5 charges of corruption in contravention of Section 3A numeral 2 and or numeral 3 and or numeral 4, read with Sections 1, 2, 20, 24, 25 and 26 of the Prevention and Combating on Corrupt Activities Act 12 of 2004. 13 charges of money laundering in contravention of Section 4A and or B, read with Sections 1 and 8 of the Prevention of Organised Crime Act 121 of 1998. I hereby officially apply for the extradition of Ms. Moroadi Cholota, born on the 10th of February 1987, with particulars as captured in paragraphs 8.1 and 8.2 above. The following documentation are attached to this application for the extradition of Ms. Moroadi Cholota. A copy of the passport photo of Moroadi Cholota, which is certified as a true copy reproduction of the original by deponent, Captain B.F. Collins. Copy of the J50 warrant of arrest, A291, which is certified as a true copy reproduction of the original deponent, Captain B.F. Collins. A copy of the original typed statement of Captain Katerina Oosthuizen, A291, regarding the application for the J50 warrant of arrest commissioned by Captain Michael Aris. The copy is certified as a true reproduction of the original by deponent, Captain B.F. Collins. A copy of the original uncommissioned warning statement of Moroadi Cholota and a copy of the typed version of this statement, as per A248. Both these copies are certified as a true copy representation of the original by deponent, Captain B.F. Collins. Copy of the original type statement of Etienne Lambrecht, A98, regarding the analysis of the electronic devices of Cholota, commissioned by Constable R. Domas. Paragraph relevant to this application is paragraph 2.2 with annexes marked as NMSC1 to NMSC17, which are the only annexes attached for purpose of this application. These copies are certified as a true reproduction of the original by deponent, Captain B.F. Collins. Copy of the original typed statement of Tsepu Muleku, A112, regarding the downloading of the electronic devices for which Cholota gave written permission, commissioned by Constable L.K. Mashehu. The copy is certified as a true reproduction of the original by deponent, Captain B.F. Collins. I hereby confirm that all copies of statements and other documentary evidence attached to this application, except for this statement, are certified by myself as true copies, reproductions of the original documents. And I further confirm that I am duly authorized as a member of South African Police Service in terms of the Justices of the Peace and Commissioners of Oath Act 16 of 1963 to certify such documents to be true copies, reproductions of the original documents. I confirm, as indicated in paragraph 12 above, that all statements, excluding the warning statement of Cholota, were originally commissioned to be under oath by members of the South African Police Service, were all duly authorized in terms of the Justices of the Peace and Commissioners of Oaths Act 16 of 1963 to certify such statements to be under oath. And do you know and understand the contents of this declaration? Yes. Do you have any objection in taking the prescribed oath? No. Do you consider the prescribed oath to be binding on my conscience? Yes. I declare that the above-mentioned statement is the truth and nothing but the truth, so help me God. Signed by Captain B.F. Collins. I certify that the deponent has acknowledged that he knows and understands the contents of this declaration. This declaration was sworn to before me, and the deponent's signature was placed thereon in my presence at Bloemfontein on the 13th day of December 2021 at 1100 hours and commissioned by Sarel Petrus Nienaber, Waterfall Building, onder Allebal Street and St. Andrew Street, Bloemfontein, Senior Administrative Assistant.
Thank you, Captain. My Lord, if this may then be admitted as Exhibit 10.
What's the purpose of this affidavit, Captain?
My Lord, it was for supporting of the extradition together with Advocate Nason's application.
So it served before the court in the USA.
That is correct. It's part of the extradition process.
Thank you.
Thank you, my Lord. If I may then hand Exhibit 9 to the witness, that we may go through the same. Captain, you have just confirmed that the purpose of this particular affidavit was in support of the extradition process made for Ms. Cholota to be brought back to South Africa.
That is correct.
And further to that, there was a detailed application brought and forwarded it to the United States of America. If I may request you to look at under File Tab B of Exhibit 9. Which title is Request by the Government of the Republic of South Africa presented to the Government of the United States of America for the extradition of Nomahanga Moroadi Selina Ms. Cholota. If you look, it's on top of B. If the filing is, the tab A is on top of tab A, and tab B, the document relevant to tab B is on top of tab B for ease of my learned colleagues as well as court.
Yes. Do we have it?
My Lord, if I may just confirm for my learned colleague, she's found the...
I didn't mind it to be, so I think it's mislabeled. It's mislabeled. Yes, it's mislabeled. This one here is B. Just like the B.
Thank you, my Lord, for the indulgence. I believe my learned colleague has found the same document.
Yes, Ms. McPherson, I see that under tab A, there is the request by the government of the RSA presented to the government of the United States.
Indeed, so my Lord. However, if we look at the way it was in fact filed, A is the chronological order of the processes. And if we look at the heads of argument deposed to by my learned colleague, it's not filed under the tab, it's A, and if you look at A, it would then be above A. So B, the relevant documentation would be the request by the Government of the Republic of South Africa. It is on top of B in terms of filing. So A would be the chronology. If we look at apologies, just 1 second. This bears reference to Exhibit 8. It was also previously submitted to the court. The heads of argument. If we look at their, my apologies, Annexure A, if we look behind Annexure A, my apologies, my Lord, it is Annexure A, a shortened extradition application for the extradition of the accused from the USA, or the exact title would be Request by the Government of the Republic of South Africa presented to the Government of the United States of America.
Yes, that is now under A.
Indeed, so my apologies, my lord.
But you have now dealt with or referred the witness to tab B.
Indeed, so my lord, I shall refer him to tab A now, my lord.
Seems to me logical.
I'll hope so, my lord. Logical and common sense. If I may refer the witness then to tab A, which refers specifically to the request by the Government of the Republic of South Africa. I can confirm that the witness does have the same, and my learned colleagues, we are all now on the same page, or the same tab, my lord. With regards to the specific extradition application, is this whereupon your affidavit was also attached to?
That is correct.
Are you aware of this particular application that had been forwarded to the United States of America?
I am.
And you can also confirm that this is in fact the application that had been forwarded on behalf of the Republic of South Africa for the extradition.
That is correct.
Lord, on that basis, if we may then have this portion of Exhibit 9 now also formally admitted.
Yes.
Thank you, my lord.
Yes.
If we may then turn to tab B. Underneath tab B, we have that there was a further request forwarded from the United States of America that had identified certain issues of clarity that needed to be addressed before they were able to entertain the matter.
Dated 26 January 2023.
Indeed so, and it's via electronic mail
That is correct.
with specific attention Edgar R. Buertis.
That is correct.
As the investigating officer of the matter, are you aware of the same?
I am.
Have you had an opportunity to, prior to today as well, to go through the same documentation
Yes, I did.
and also to be able to provide answers with regard to the questions?
Yes.
Did you provide answers to, my apologies, the questions raised?
Yes, I did.
My lord, then if tab B to Exhibit 9 may also be admitted as a formal exhibit.
Yes, it is so admitted.
My lord, if we may then turn to Exhibit D. The heading there, tab D, not Exhibit E, my apologies. The heading there would be Motion to Proceed with Extradition Hearing, filed on 05/21/24, being the 21st of May 2024, with the top heading of page 1 of 5. Captain, do you see the same?
I do.
Have you had an opportunity to peruse the same?
I did.
Was anything required of you with regards to this particular documentation?
No, this was basically just a certificate to show that the Americans received it and Cholota's procedure thereafter.
With regards to, if we may pause there briefly, my lord, first that this also become formally admitted, tab D, if it may be formally admitted as an exhibit.
Yes, so admitted.
Thank you, my lord. If we may pause there, Captain, You speak of the processes that Mayor Cholota followed with regard to this. Can you provide clarity on that?
This would have been after she's been arrested, it seems, that the procedure she can follow in the US by seeking other legal means to question her detention as part of the extradition.
To the best of your knowledge, did she attempt to seek any other legal means in the United States of America at this time?
At the first stage, yes, but then she dismissed the request, if I can say it like that.
When you speak of her request and thereafter she dismissed her request, what specifically are you aware of what she had wanted to undertake?
Just repeat that for me, please.
What are you aware of? What at this stage did she initially want to seek?
She wanted the extradition to be stopped, so she asked for a continuance in the American court and to file certain documents relating to the continuance, and it was granted on the objection of the American state attorneys. But if I recall correctly, I just want to make sure that there were no documentation filed after the continuance was granted. So Ms. Cholota and the legal representatives never filed any papers on behalf of that motion that she submitted that.
If we then move to Annexure E or Tab E, specifically titled the Memorandum Order and Certification, this then dated 06/07/2024. And this is then under Tab E. Do you see the same?
I do.
Have you had sight of the same?
Yes, I did.
What is your understanding of what this particular documentation is?
This is the order that is issued in the certificate for extradition after all the legal processes were followed in the US by Ms. Cholota and all the other processes. So this is basically the certificate that she can be extradited to South Africa, and she be kept in the custody of the United States Marshals.
During the particular process of the extradition application, you had submitted your affidavit, but you were not required to give testimony.
No.
My Lord, if this then tab E may also be marked as a formal exhibit.
Yes, it is done like that.
It is also ultimately that this was then referred to the Secretary of State to make the final extradition order, which we can, it is tried that it was done so, as Mayor Cholota is in fact in the Republic of South Africa.
That is correct.
At this particular time, we also have further electronic communications, as you have already referred to in your evidence. If I may then lead you to tab G. My apologies, my lord, if we may go to tab F first. My apologies. The email correspondence inter alia between the state, Mr. Nkwashu, and the attorney of the accused at the time. Do you see the same?
I do.
You also are able to see specifically through correspondence dated 28 February 2023. You'll note that you are also part of that particular email trail.
I note that, yes.
You have also had sight of these particular communications.
I did.
And in these particular emails, there is also further reference to discussions of Cholota having been taken into custody on a separate, unrelated matter. Is that correct?
That is correct.
Do you have knowledge of that particular incident?
No, it was not on our request, and we did not get any feedback on the reasons why. We only assumed after a mail of Ms. Maria Lerner that it was regarding a study visa that has expired.
That was investigations of their own doing, the United States of America.
That had nothing to do with us.
Were you aware of the specific visa requirements that Cholota did have at that particular time to be able to be resident in the United States of America?
Yeah, I'm not sure of the dates for the expiry of the visa, but there was a time limit on that, and it was clear that that visa expired. And it seems that is the reason why it was arrested.
But to reiterate, that was not of any doing of the investigations relating to the particular matter while we are at hand here today. And in this particular email trail, it makes specific mention on the email dated the 16th of February 2023 at 11:17 that a question was posed to the erstwhile legal team requesting as to whether or not the client was still prepared to come to the Republic of South Africa. It is on page 10. My apologies, they are not numbered. However, if you are able to turn to page 10, dated the 16th of February 2022. Do you see the same?
I do.
Were you aware of that specific communication, again confirming an undertaking?
Yes, I was.
Are you then aware what later transpired as to why Cholota never returned to the Republic of South Africa as per her own undertaking?
Well, she did an application in South African courts for the extradition to be set aside.
If we may, then that, I believe you are speaking to Annexure G. Where it refers to documentation of in the Constitutional Court of South Africa, the founding affidavit of Moroadi Cholota. Is that what you're referring to?
That is correct.
Had you had sight of this particular documentation prior to today?
Are we talking about the Constitutional
The
Court?
Constitutional Court application?
Yes, I did.
What was required of you after having received and had sight of the application, the founding affidavit of Moroadi Cholota?
I had to give an answering affidavit.
Therefore, you would have had to have perused Annexure or tab, my apologies, G or Annexure G.
Yes.
My Lord, if the same may then also be received formally as an exhibit, being Annexure or tab G.
Captain, what was the purpose of this proceedings initiated by Ms. Cholota in the Constitutional Court? What did she want?
She wanted basically the prosecution to stop against her in South Africa. Based on the fact, the allegations is that we didn't have the relevant evidence, that there were no implications made by other investigation institutions. So she just basically wanted to stop the extradition.
Thank you.
Thank you, my Lord. Captain, it is also then correct that you provided a replying affidavit based on the application moved by Moroadi Cholota in the Constitutional Court. And that would be found under Annexure HI or tab HI of Exhibit 9.
That is correct.
Do you see that particular document?
I do.
Do you confirm that that is in fact your statement provided?
Yes, it is.
And that it was in direct response to the application lodged by Moroadi Cholota?
In the Constitutional Court. Yes.
And attached further to your specific application, if we turn to AA2, or for my learned colleague's sake, reference in terms of the docket, it is also A248, a formal warning statement. My Lord, if I may perhaps request that I have sight of the court's copy that I can flip slightly faster to the same for the ease of the court. This is in specific reference to the warning statement.
That is correct.
Earlier on, whilst giving your evidence, you spoke specifically of a warning statement. Is this the same documentation?
Yes, it is.
Upon completion of this particular document, who all was present?
It will be General Gerber, myself, and Ms. Cholota.
Previously, you had spoken about a special agent being. Where was she at this particular point?
As soon as we started with the taking of the warning statement, we asked her to leave the office because that procedure had nothing to do with the US. So she wasn't present during the taking of the warning statement.
If you may then walk us through the sections as you had earlier indicated. You spoke of the warning statement being made out of two parts. If you can refer to us what exactly you mean by that.
There's a section that starts with the reading statement regarding interview with the suspect. It is the 4th page of the warning statement. The first part is basically just a description of how to complete the warning statement. The official statement starts on the 4th page. Unfortunately, the pages are not dark. The second page, from the second page on, it is numbered, but the statement regarding the interview with the suspect, that is now my statement that I have with the suspect. It will basically show the person who I'm interviewing, my details, person who I'm interviewing, and then who is present during the taking of this warning statement. Then paragraph 2 is the alleged charges against the suspect.
If I may refer you back to that paragraph 1 where it specifically indicates who was present. I see you do refer to Brigadier Gerber, and then later on you also mentioned that Special Agent Bean. Can you please explain to us what happened there?
Yeah, Special Agent Bean, as I noted here, of the F guy excused at 11:26. That's when she was asked to leave the office.
Yes, Captain, please carry on.
Paragraph 2 is a short summary of the charges. This is a very broad description of the possible charges that could be laid against the suspect with no particular details of the charges. Those specifics will be handed over to the suspect as soon as the decision has been made that she will be charged, and then the charge sheet laying out all the charges and specifics will then be handed over to. So this is basically just a summary of the alleged charges.
There are also a variety, if we go to paragraph 3, that there are certain aspects that need to be taken up with regards to the person that you're interviewing, as well as their on out.
Yes, that is now the rights according to the Constitution that is set out where she can remain silent throughout the interview, do not have to ask any questions, can have a legal practitioner present of her choice, or then which you prefer, and if she cannot obtain one, the state will provide one to her.
Did you go through these various rights with Moroadi Cholota?
Each and every one of these.
How can one confirm that they were in fact gone through with Moroadi Cholota?
She initialed next to each, or a change that is made in that paragraph, he, she, and then she signed at the bottom of each page.
At this particular point in time, what was her demeanor then like?
Not happy and confused, and obviously arrogant and aggressive, I can say.
Yes, Captain, if you can walk us through the rest of the warning.
Okay, number 4 is where she requires, where we would ask her whether she prefers to get a legal practitioner parent or a guardian. And there are three choices, of which two were scratched out where she initialed. And she made the choice to wish to consult with the legal practitioner of her choice. So she made a decision to look for a legal practitioner. And then after that, because there wasn't one present, the following steps. An interview I held at Washington, is an embassy, and no legal representation are available at this stage. The note is made that after we requested if there is someone present. And then as well, that given the opportunity to consult with a legal practitioner of her own discretion, a copy of this statement will be handed over. So you must read this in contents after the whole affidavit or the warning statement has been completed. Then a copy of this on request will be handed over to a legal representative.
Yes, Captain.
Page 3. There it is asked if the suspect wished to make a statement in relation to the allegations against her. And then there's also certain choices, of which she chooses number C, which that says, would personally see to the drawing up of a statement and would furnish me with a statement on or before the 23rd of October 2021.
And as already indicated earlier on, the same has not been done.
Same has not been done.
If we look at page 4, there are further requests made specifically to the person that you're interviewing. If you can explain those to us.
Well, this is part just to ask whether the suspect has any injuries, and if she does, where did she obtain it? And there were no injuries noted that she identified, and it was stipulated like that.
If we look to the next block, there are further requests made.
Yes. Then the suspect is asked if she in any way has been threatened, assaulted, or influenced to exercise the foregoing options. And then the suspect has said she was not threatened, assaulted, or influenced.
I see again on the side of these paragraphs where there are certain deletions made, there is an N, an M, and an S. What does that stand for?
That will be Ms. Cholota's initials after certain points were scratched out for her confirmation.
If we look at the final block on that specific page as well, who is to make that specific observation? Where if we look at paragraph A, the suspect was seemingly of sound mind and did not seem
Yes, under the influence of liquor. Yes. Well, for us it doesn't seem so, and she was asked as well if she had anything alcoholic to drink, and she said no. So she was of sound and sober mind when the taking of this affidavit was done.
That then brings us to page 5, there is specifically with regards to block 10 that the interview was interrupted during the periods and for the reasons as set out below. Can you explain that to us?
Yes. This is when Ms. Cholota, when the taking of the statement, of the warning statement started, and she indicated that she wanted the legal representative present. So this is to note when this interview has been breaking it, and then you have to describe exactly why. And as it is clear here, this is when General Gerber went and looked for a possible legal representative for Ms. Cholota.
However, that one was not found.
No, there wasn't.
It was also indicated that there had not been an interpreter present.
Yes, that was asked as well, and she said no, she is fine with English language.
And even during your interview prior to the taking of the warning statement, were there any hindrances to your communications with her based on language?
No, the questions and everything was quite clear, and at no stage, if something was unclear relating to a question, it would have been, it was explained to her, but there was no communication, lacking communication.
And ultimately, she also confirmed that particular page of page 5
Yes.
by statement. With regards to page 6, you've already indicated that a statement would be provided in October of 2021.
Yes, this is the second part of the warning statement where the official, if the suspect decided to give an explanation, then this part would have been completed. This is the official affidavit from the suspect.
But as is clear from the statement itself, that Ms. Cholota did not actually give you what we would deem a warning statement. There was nothing that was contained of evidence.
No.
And then further up until the point of page 9, where it was merely only signed, as well as page 10, where it was finalized on the 23rd of September 2021.
That is correct.
My Lord State will also therefore request that this annexure HI / tab HI as well as attached documents are further also submitted to the court as a formal exhibit.
Yes, it is accepted as such.
Captain, if we may then turn to annexure or tab JK. This is also further documentation of the Constitutional Court of South Africa, being a replying affidavit that had been submitted by Mayor Cholota through her legal representatives.
That is correct.
Are you aware of such document?
I am.
Have you had an opportunity to peruse the same prior to today?
Yes, I did.
Captain, was there anything further that you had to respond to the Constitutional Court on based on this particular application or the replying affidavit? To the best of your knowledge?
Yes, if I recall correctly, yes. Yes, I did.
What aspects were raised that needed to be further addressed?
The manner in the way how we handled her in America. Part of the application was that she felt threatened, intimidated by us, and the fact that we didn't give her the opportunity for a legal representative.
Are you aware of what transpired with this specific application to the Constitutional Court?
It was dismissed with costs, if I recall correctly.
My Lord, if this annexure JK may also formally be admitted as an exhibit.
Yes, it is so admitted.
If we may then turn to annexure L or tab L. This is specifically a further notice of motion that was filed by Mayor Cholota to the High Court of this specific division. Are you aware of the same?
Yes, I am.
Have you perused the same prior to today?
Yes, I did.
Are you aware of what the specific requests were that were brought through this application?
This once again is part of the delaying of questioning the extradition charges, and that the court doesn't have the authority.
If I may request you to look specifically, apologies, my lord, on page 2 of the application. These are what is sought by the applicant in this particular matter. If you can just read those onto record as well. From paragraph 2 up until paragraph 6.
The facts contained within.
No, from the notice of motion, page 2. If you go right to the beginning of annexure L, and on the second page under the notice of motion.
Yes.
PLC.
From point 2.
Indeed, sir.
Okay. That the prosecution of Nomaghlanga Moroadi Cholota on charges of fraud and corruption is declared unconstitutional and invalid. Number 3, that the conduct of the state in the extradition of Nomaghlanga Moroadi Cholota renders the extradition unlawful. Directing that the Director of Public Prosecutions in the Free State withdraw the unconstitutional charges against Nomaghlanga Moroadi Cholota, and then cost in respect of the parties opposing and granting the applicant further and or alternative relief.
And this again, you were then requested to depose of an affidavit in response to the same.
That is correct.
My Lord, if this annexure L/tab L may also be formally admitted.
Yes, so admitted.
Please. If we may then turn to Annexure M or Tab M. This is a document that is also to be filed in the High Court of South Africa, Free State Division, under case number 4698 of 2024. This was with regards to you answering on behalf of being the second and the third respondent answering affidavit. Do you see the same? Did you in fact complete this particular affidavit?
I did.
You will note that at the end, the copy that is submitted to the court is not the copy that had been signed by yourself. However, if I may ask that, as we have discussed the same, if you can go through the same and confirm that that is in fact the same affidavit that was later on submitted to the court.
Yes, I went through it and it is the same affidavit.
And I see that barring that paragraph 2, where there was just aspects of the designation of Lieutenant Colonel Tlali.
Yes.
And this was made in response to the application brought by Major Cholota.
Would you say again?
That this was made in response to the application brought by Major Cholota.
That's correct.
My Lord, if this may then also, perhaps due to the fact that it has not been formally signed, if my witness may just read the same into record that he can confirm, unless there is no objection from my learned colleague, that we may admit the same as an exhibit.
Are you referring now?
My Lord, could we get the reasons why an unsigned copy of his affidavit is what he is?
Yes, that is now the affidavit of the witness, Mr.
Indeed.
Captain Collins. And the copy that I have is not by C. It's got 43 pages. There's no signature of the deponent, nor is there a signature by the Commissioner of Oaths, and you want to know
Indeed.
the reason.
And we've got comments from counsel on particular points. So in the event that perhaps that was fixed or that was deleted, that this would not then be the original that he deposed to. And so if there is an original copy, we would request that that be admitted into.
Yes, Ms. McPherson?
My Lord, that was merely due to the time constraints of having to have the documentation prepared from the one evening to the next evening. We do in fact have the same documents that were submitted by or to my learned colleague in the High Court application. We are also able to then copy the same and provide the same. However, it's not going to take us any further. It's mute, as it is already indicated. There's only the one paragraph that there had been a comment, not various comments by counsel on the same. Perhaps for the sake of ease, it would be better that we make a copy and supplement. If no objection by my learned colleague, I'll provide the same to her during lunchtime, that she has ample opportunity to peruse and ensure that it is in fact the same documentation.
Yes. Can you perhaps quickly show
Indeed, sir.
that document to her for the moment?
Absolutely, my Lord.
Ma'am, may she proceed with the document for now, or what is your view?
She may proceed, my Lord.
Thank you. Thank you.
Thank you, my Lord. My Lord, we will endeavour then during the adjournment of lunch just to make the relevant copies. However, if we may then proceed with the document that we do have in front of court, being Annexure M or Tab M. Captain Collins, this is as indicated the affidavit that you had made in response to the application brought, the further application brought by my learned colleagues to specifically the High Court with regards to the purposes of extradition. Is that correct?
That is correct.
And you had also had ample opportunity to first peruse the affidavits supplemented by my learned colleague or the accused person with regards to Annexure L that we have already submitted to the court prior to making this.
Yes, I do.
If you then may proceed to read this specific affidavit into record as well. Your Annexure M for
May I ask if I can sign it?
Why is it necessary for him to read it out? Aren't there specific paragraphs that you want him to question him about?
Indeed, so my lord, I was just concerned due to the potential discrepancies that my learned colleague was wanting to bring to light that we can have that null and void, that not be the case. However, if we can refer specifically to paragraphs, we can do that, as it will greatly save time.
Yes, I don't want the captain to read out this whole statement. It could take us, it could keep us here till 5 o'clock this afternoon.
Indeed, so my lord. Even though he does have a very nice voice, we don't necessarily want to be kept by that.
Do you agree with me, Miss?
My lord,
You-
is the submission that Captain Khaled has to read it into record because I noticed that it was unsigned? Is that the state's submission? I'm just not understanding what I'm
Indeed, so my learned colleague had a concern due to the fact that it was unsigned, so we are confirming the fact that the signed version is in fact one and the same. However, that's why I requested, if it's not an issue, that we then go forward with the specific relevant paragraphs,
Okay.
if I may just be guided.
Are you satisfied at the moment that this unsigned version is the same as the original?
Indeed, my lord, I had sight of the signed version.
Okay, so is it still necessary for the captain to read out the whole statement?
It certainly was never necessary in the first place, my lord.
Thank you. So if there are any specific portions of the statement you want to raise with the witness, please proceed.
As it is the court, my lord. Apologies, my lord, just 1 moment. If you look specifically at paragraph 18, the heading thereof is the overarching basis of opposition. If you are able to find the same. Paragraph 18 specifically, if you may read that into record.
It is denied by the second respondent that any persons in his employ acted in any unlawful or unconstitutional manner with regards to the applicant and the criminal process put in place against them. I personally deny that I have ever acted unlawfully or in an unconstitutional manner towards Ms. Cholota. In fact, I believe I accommodated her request as much as I could and went out of my way to assist her during the interview process.
Now, Captain, you've also further already testified to the fact that there were certain arrangements made with Ms. Cholota with regards to how she had arrived at the first day of the interview, thereafter terminating it early to get to varsity, as well as even meeting with a boyfriend. Are there any other aspects which you indicate that you've gone out of your way to assist her during the interview process?
Just the ones that I've mentioned, as I said, I was speaking to the boyfriend, accommodating her to attend classes, her contacting a legal representative on my request, and as well the second day picking her up, driving with her own vehicle back and forth, attending class the second day again where we dropped her off. So we accommodated wherever we could on her request. There was actually no request from her side that we did not accommodate.
Now, it is also correct that the basis of that particular application was that the extradition process be deemed to not have taken place correctly. Is that correct?
That is correct.
However, in all your dealings, you've submitted the necessary affidavits.
Yes.
And attached to your affidavits, what evidence did you provide the United States of America with?
Well, summary of the investigation, the emails between the different parties, financial flows as per request on the emails were provided, and then the basic allegation of the 4 charges of corruption and money laundering.
And ultimately the decision was made by the court extraditing Ms. Cholota on the facts provided.
Yes.
Was it merely your own statements that were provided to the United States of America, or was there other objective evidence?
There was an affidavit of Sumaru, the DPP, and then as well as affidavit. And then for the warrant of arrest, Captain Westhuizen did the affidavit on the application of the judge.
With regards to, my lord, if I may, we will bring that this be formally admitted after lunch once we've made the necessary copies that we can hand the formal statement into form. With regards to this particular application that had been brought by my learned colleague, are you aware of what the outcome was?
This was also dismissed.
And this is furthermore attached as per Annexure N, or Annexure O, my apologies, I see the heads of argument refer to 2 Annexure N's.
Yes, but it is under tab in.
Indeed, sir. The same may then also formally be admitted.
Yes, it is so admitted.
Very briefly, Captain, if we look at the special plea brought by my learned colleague, it's specifically with regards to whether or not this court has a jurisdiction. Are you aware of the same?
Well, we submitted all the evidence that we obtained implicating Ms. Cholota, all her involvement in this whole scheme of the awarding of the asbestos contracts. We submitted each and every document to the United States. If they had more questions to clarify certain aspects, it was submitted. So they had everything in their possession to make the necessary decisions as they did. They actually said that we aren't allowed to charge the money laundering. We complied with that. That is after all the documentation were handed to them. And they confirmed the charges of fraud and corruption as per the information and documentation provided to them. Nothing else was withheld. Nothing was fabricated. It was documents legally obtained from various individuals, institutions, and that is what was handed over to the Americans. And they made their finding based on that.
It is also the special plea that the state had lied or misrepresented to the United States authorities that there was reasonable and probable cause for the charges brought against Ms. Cholota, or accused under 17. What is your response to that?
Just repeat that for me, please.
That the state lied or misrepresented to the United States authorities that there was reasonable and probable cause for the charges brought against Ms. Cholota / accused 17.
Yeah, no lies, nothing. No. As I said, nothing was fabricated. All the evidence was obtained officially. So what they had was what it is against them. Allegations.
They also put forward that the state lied or misrepresented to the United States authorities that accused 17 was a fugitive from justice. What is your response to that?
Well, we only notified or made mention that she flew to Kenya. That is something they followed up, they could have followed up themselves. But it was not part of the extradition application, the fact that she's a flight risk. The extradition is based on the facts and the merits of the case.
And that ties in furthermore with the submission that the state lied to or misrepresented to the United States authorities that accused 17/Ms. Cholota was a flight risk with connections in Kenya.
Well, well, they were informed, but that is not part of the extradition. It's not basis for denying an extradition. Extradition is based on the facts of the case. The ties with another African country will come into play during the course of the bail application.
And furthermore, Captain, just before we close for lunch, it was also allegations that there was a political motivation in order to charge Mayor Cholota, as well as her political opinion resulted in her being arrested. What do you know of that?
I know about these allegations, but there's no truth to it.
Are you even aware of what her political opinion is?
No, I am not.
My Lord, save for the handing in of Exhibit N, or Annexure N, my Lord, I have finalised with regards to this witness report. I'm not sure if it's convenient time to adjourn now, as it is already 12:52, that we can provide the same copies to you, please.
Yes, no, certainly it's a convenient time. I just have a question. Captain, I do not know what happened in the US. I wasn't there. You were there. My question might seem very simple to you, but this extradition hearing, did it happen in an open court? Did it happen behind closed doors on the papers only? How did it happen?
Well, according to my information, it's only based on the paper submissions that was made by the various parties.
There was not a magistrate or a judge sitting on a bench.
Well, I think there was a judge. I'm not exactly sure of the process, but there should be a judge making the
You were not present?
No, I wasn't.
Yes. Now tell me, when you say the mention of a Kenya connection and so forth did not form part of the extradition application.
Yes.
What do you mean by that?
That is a mere fact when we followed up, my Lord, on movements.
Yes, but was it placed before the court, before the judge? Was it mentioned to him?
Not to my knowledge. Only the facts in the case was mentioned to him.
Who appeared for the South African government in those proceedings?
That will be the US, the DOJ, Department of Justice, that side.
There was nobody from South Africa
No.
there. And as far as you know, the papers that were submitted to the magistrate or the judge, was there any reference in those papers that is now coming from the South African side? Were there ever any reference in those papers to Ms. Cholota having connections or family or whatever in Kenya?
Lord, I will lie if I say yes. I can't recall.
You cannot recall.
I cannot recall if that was part of that. I think not, but I cannot say for certain, unfortunately.
Was there any allegations before the US court coming from South Africa that she was a fugitive from justice?
Not directly, no. It is only basically the facts that was set before them, stating the procedures we followed to get there. The fugitive status for them, no, I can't recall that that was addressed to them itself.
Thank you. I notice it is now just about 1 o'clock. We will now take the lunch break and resume again at 2:15.
My Lord, my Lord, if I may, before we take the adjournment, I received instructions from accused 14 and 15 to request the court, while this jurisdictional issue is being entertained by court involving 17 and possibly accused 11, their attendance, that they be excused from attending court. I will remain in court and in contact with them if I need any instructions or their attendance be required.
Yes, isn't that something that we can deal with at the end of the day? Why must I now pay my attention? I've already said the court is adjourned.
Wish to address the court?
Yes, sir.
As a proceedings, my lord. My lord, I would just like to bring to the attention of the court and seek indulgence at the same time. My client is just went to a quick meeting outside and said he'll be 15 minutes late. If you saw the court may grant him indulgence to come in a bit late, quite
He should have the courtesy, I thought, of asking that before he went out to the meeting, not after he went out.
My lord, unfortunately, he didn't anticipate it would take long, so he immediately called me as soon as he...
Is he still here in the building?
He's not in the building, my lord. He's just the close of 2 hours.
Yes, will you inform me when he comes back?
I will do so, my lord.
Thank you. Ms. McPherson?
Thank you, Lord. I believe I can now continue. My Lord, prior to the adjournment for lunch break, we had referred specifically to Annexure M/tab M, which had been the signed affidavit of the witness before court that was to be finalised as an exhibit. I have submitted copies to my learned colleagues. If we may then submit the same to the court, that it be supplemented or swapped with that is in the file, and this be formally admitted as an exhibit, Annexure M. That forms part of the entire bundle of Exhibit 9, my lord.
Yes, it is. So admitted. Thank you.
Thank you. My lord, then at this juncture, then the state is finished with question with regards to the witness before court. Is it please the court?
Yes. Are you ready for cross-examination, Ms. Magashule?
My lord, I confirm that I'm ready.
I'm also ready, so you can proceed.
Thank you, Captain Carlitz. Could we please start with tab HI? That would be the Constitutional Court Affidavit. Page 5. Paragraph 13, please. Thank you, my lord. Captain Collins, could you please read out paragraph 13? But before you do, please confirm that this is in fact your affidavit that you deposed to.
It is. I've signed it at the bottom.
Could you please read into the record paragraph 13?
At this stage, Ms. Cholota had not been cited as an accused in the Asbestos project case because she had cooperated with law enforcement authorities.
Now, time and time again, we see the phrase cooperate come up in various affidavits. What does it mean to cooperate in this context?
Well, in this context, she gave the indication with correspondence with the Mason and with General Gerber that she's willing to cooperate with the state and that she will give a full cooperation in anything in the state she's, well, she will be a state witness in short.
And speaking of that correspondence, you mentioned in your evidence in chief that there was various communications between Gerber and Denishan and Ms. Cholota. We could only identify 2 pieces of communication. Is that the various communications that is being alluded to?
That could be yes.
And so she had only communicated with Advocate Dineshan once and Brigadier Gerber once.
I can't recall the correct total of times, but I know there was communication between them. Whether it was once or twice, 3 times, that I cannot say.
Fortunately, we do have that communication. My Lord, I beg leave to hand up as Exhibit PQ the communication between Advocate Dineshan and Ms. Cholota and Brigadier Gerber and Ms. Cholota.
Yes. Under what tab is that?
PQ.
Yes.
My Lord, I confirm that the state has been sent these email communications. They were in fact attached to the opposing bail affidavit originally, and that is how we came into contact with them. They were provided by the state. Now, Captain Khalid, you are copied in each of these emails. Could you confirm that that is your email address?
Yes, please.
Okay. And that you are aware of this communication?
Yes, I am.
Could you please read into the record the first paragraph that the state prosecutor intimated in his communication to Ms. Cholota?
I'm talking about the 18th of November.
That would be the 18th of November, 8:16.
You have submitted affidavits and have testified before the Commission. I am satisfied with your version. There are only a few aspects that I want to clarify with you. We shall get to that as soon as we meet. Precisely when, I cannot say now, as it has been determined yet. So at this stage, to answer your question, you will basically be required to testify to what you have stated in the evidence before the Commission read together with your affidavits.
You will basically be required to testify to what you have stated in your evidence before the Commission read together with your affidavits. Which commission would this be?
That will most probably be the Zombie Commission.
The State Capture Commission.
That's correct, yes.
And that evidence that is being spoken about is her evidence before the State Capture Commission?
Yes.
And so if I'm understanding it correctly, it is reassuring her that the reason the investigators wish to meet with her is in relation to her testimony at the Zondo Commission.
Well, at this stage, yes.
At this stage. All right. And then could you please read into the record the third paragraph that begins with your testimony?
Why, that's something you do not have the full details about. But please rest assured, you are not one of a great number of witnesses in a much bigger picture. I will not expect you to testify about aspects that you do not have knowledge about.
I will not expect you to testify about aspects that you do not have knowledge about. Can we confirm that this was the state prosecutor emailing a prospective witness?
That's correct.
At this time, she was not a state witness.
Well, at this time, no, she was still a state witness.
This is the initial communication. This is the very first communication. Perhaps we can go to her email at the bottom of the page.
Mm-hmm.
Could we start with good day? That is an email from Ms. Cholota to Brigadier Gerber, and yourself and Advocate Dineshan are copied into this email. Do you recognize that email?
Yes, I do.
And the date there?
17 November 2020.
Could we please start with the first paragraph?
Also, please assist my ignorance. Do I understand you to be saying that I have not agreed to be a state witness in this, or at least submit an affidavit before? Meaning you or anyone in the police or EPA have not spoken to me before. I am struggling with your email when you say that I am hereby informed that I will be called as a state witness without you even telling me what I will witness about. At least you can be courteous and tell me what I will witness about. I feel it was unfair to me with the prosecutor announced in court and in front of TV cameras that I am state witness without my knowledge.
And so can we take it to mean that when she sent this email, she was not aware that she was a state witness?
Well, at that stage she was aware because she sent the email.
And how would she have become aware? I think the first paragraph informs us.
Well, it was announced in court.
And so prior to that announcement, did she know?
No.
And so it was announced in court, and then she emailed seeking clarity. This was her first email seeking clarity as to whether or not she was a witness, correct?
That's correct.
And so can we reasonably then assume that she was not a witness if she did not know that she was a witness?
Well, prior to this, yes, she wasn't, or she didn't know about it.
Thank you, Captain. Is there any communication between Ms. Cholota and Advocate Denieshan, or between Ms. Cholota and Brigadier Gerber, that you are aware of beyond this communication?
Are we talking now about before the 16th of November 2020?
Before the 16th of November 2020.
I can't say that I'm aware.
And between this intervening period of the 18th of November and the 22nd of September 2021, the following year, when you went to interview her, was there any communication between Brigadier Gerber and Ms. Cholota, or Advocate Denieshan and Brigadier Gerber, that you are aware of?
No, I'm not aware of anything.
And so I come back to my original question, Captain. The various communication is only alluding to a single email between Ms. Cholota and Advocate Denieshan.
Well, then it is that, yes.
A single email.
Yes.
And so we come back to the cooperation. Where in this email is she indicating her cooperation?
Which email is that, Ms.
The only email that she would have sent, my lord, that would be the
that
email
is the
at
one
the
starting
bottom.
with good day.
Good day. That
Yes,
would be the
okay.
email, my lord.
Well, I would say, paragraph 4, please don't confuse my ignorance with a reluctance to assist my own country in an investigation, but I feel that you should have had the courtesy to consult with me before you went public on a contract that I still do not have details on.
And that would be the cooperation.
Well, that clearly would give me the intention and the indication that she has the best interest of the country.
Indeed. And so we get to, if we could return to tab H1 again, that would be the Constitutional Court affidavit by yourself. Page 15, 1-5. Paragraph 14, 1-4. My apologies. It seems it is page 5. My apologies, my lord. My apologies, Captain. Page 5.
Yes.
Paragraph 14.
I am advised that the decision of the Director General to approve the unlawful request for extradition by the National Prosecutor.
No, sorry, that's not it. A tab HI,
The Constitutional Court.
the Constitutional Court.
This is what I have for paragraph 14.
The third respondent's answering affidavit, HI.
Mine isn't mine like that.
Get him back. Get him to stay so please. I think let's get you a new one. So that would be tab HI, page 5, 14. If you could read that first part of the paragraph for us, please.
The interviews with Ms. Cholota were arranged through Special Agent Ms. Denise Bean of the Federal Bureau of Investigation. Special Agent Bean was at the time based in the corresponding embassy in South Africa. The FBI had previously located Ms. Cholota in the United States and they made arrangements for a small team to drive to her residence and escort her to attend an interview with Brigadier Gerber.
And why was the FBI called in to arrange?
We don't have jurisdiction that side.
Right. What about Skype, Zoom, Microsoft Teams? Could the meeting or the interview not have been held via Skype, video, any video conferencing?
It's possible.
What was the reason this was not done?
That was not the only work to be done that side.
It still does not quite answer the question. Even if the investigators were in the United States, what was the reason for an in-person interview if a virtual one could have been arranged?
If you want to hear the fact that a person isn't called, a witness at that stage, if stuff would have changed, it would have made it difficult. I don't actually understand, but what you mean. It's our decision whether to go or whether to Skype someone. Me personally, I don't like to interview a person over electronic device. There's a lot of demeanors that you have to see when you're talking to a person. That's only my personal experience. So I can't say there's a specific reason why it wasn't done on Skype or whatever. The decision was made to go there in person.
Now, okay. I'll pause that for there. In the paragraph that you've just read to us, it stated there that a small team drove to her residence together with yourself and Brigadier Gerber. Could I ask what the need was for a small team to accompany 2 policemen to go and interview a witness?
Well, they weren't all present for the interview. It's their procedure as well as ours that one person or official doesn't do work on their own. And Special Agent Bean was accompanied by 1 or 2 of her colleagues. That is not a rare thing or strange thing. This is how it happens everywhere.
In the same affidavit, in the next paragraph, it's 2 or 3 agents. Is it 1 or 2 or 2 or 3?
Well, if I can recall, there were 2 other gentlemen, so they were 3.
So it's 2 other gentlemen, Special Agent Bean, yourself, Brigadier Gerber.
Doing what?
That went to Ms. Cholota's residence.
Yes.
So 4 men, 1 woman.
Yeah, but we weren't involved in anything like that.
I see.
So there were only basically 2 male agents and 1 female agent.
And then on the way to the Sheraton, the 3 agents fell away. Or did they accompany you as well to the Sheraton?
Well, Agent Bean drove us in her car, official car.
And
Other 2 gentlemen drove in their car.
to the Sheraton.
Yes.
Captain Kalitz, are you confirming that there was a point in time where Ms. Cholota, as a state witness, was in the room with 3 FBI agents, yourself and Brigadier Gerber?
Which room are we talking about?
The room in the Sheraton.
No.
And so at which point do the FBI agents fall away
The two gentlemen stayed outside.
and did not drive with you?
No, they drove to the hotel, but they didn't enter the room.
Right. And so there was never a time where it was the 5 agents and policemen together with Ms. Cholota?
Well, only during the transporting and arriving at the hotel.
And so there was a period where it was the FBI agents, the 2 South African Hawks policemen,
Yeah,
with the witness.
Yeah, together.
Captain, I put it to you that the reason for this was to intimidate Ms. Cholota right off the bat. What do you say to that?
All I can say is that's your opinion.
Right. And what do you say to the, if I put it to you, that the reason to intimidate her was because the investigators knew what they were going to do with Ms. Cholota even before she was informed that she was a witness? What do you say to that?
I don't understand what you mean.
I put it to you, Captain Karlitz, that before the investigators, which would be yourself and Brigadier Gerber, even left for America, the intention behind interviewing Ms. Cholota was to intimidate her.
No.
No. And so I bring it back to the question again. What was the point of having 3 FBI agents and 2 Hawks police officials in the same room as a state witness?
We were never in the same room.
In the same vicinity?
What would they have done? Where would they have been kept? Should they stay at the residence? What? They accompanied us.
Thank you, Captain. Can we move on to page 6, paragraph 18 and 19? Yes. My lord, are we all at the same page?
I'm now coming to the same page. Did you refer to paragraph 19 and?
Paragraph 18 and 19, my lord.
Yes, thank you.
From paragraph 18. Okay.
When we arrived at the hotel, we proceeded to the conference room arranged for us. Present in the room were Brigadier Gerber and I, Special Agent Bean. We did not intervene in our questioning, and Ms. Cholota. I introduced myself and explained the purpose of the interview, being that we wanted to interview Ms. Cholota and take a statement as regards the events pertaining to the Asbestos project in the Free State over the period 2014 to 2017. Ms. Cholota attended the interview voluntarily, and we informed her that she was to be a witness for the state, and we had questions for her based on her statements and testimony before the State Capture Commission of Inquiry. Also, email correspondence she had sent and received while employed at the Office of the Premier of the Free State.
We informed her that she was to be a witness for the state, and we had questions for her based on her statements and testimony before the State Capture Commission of Inquiry. Is that correct?
Yes, according to my affidavit.
Thank you, Captain. And had you informed Ms. Cholota that this interview was to take place, or that you were on the way, or that you would come at a specific time? Was there any information that was relayed to her on that score?
No, not prior. No.
And so are we correct to then say that the FBI agents, together with the policemen from the Hawks, were at her home unannounced?
Yes.
Are we also correct to say that the interview took place without prior preparation on her part and unannounced?
Yes.
And
Ms.
that
Macapello, would you please be so kind to give me opportunity to
My
record
apologies,
what
my
you
lord.
are asking?
it's my excitement. My apologies, my lord.
It also excites me if you go that fast.
Two questions on unannounced domestic.
Yes, thank you.
I repeat the question that the 2 agents, so the 2 policemen from the Hawks, together with the 3 FBI agents, Miss Bean included, attended to Ms. Cholota's residence unannounced?
Yes.
And that the interview took place without any prior preparation or information about the interview to Ms. Cholota from the state's investigators.
Yes.
Now, the paragraph that we've just read, it states that you informed that you had questions based on her statements and her testimony before the State Capture Commission. My Lord, I beg leave to hand up Ms. Cholota's affidavit as handed in to the State Capture Commission of Inquiry. Leave to hand this up as tab R in the...
Well, there's already an exhibit 10 apart from this bundle of containing tabs, so this might as well be exhibit 11.
So the way that I think, because I had said tab PQ, it's just an addition to the tabs that already exist in the file. And
Right.
so it's just the sequence that I thought would be a little bit easier.
Yes, I'm then filing it under PQ.
Tab R. Tab
PQ.
R. The email correspondence was PQ, my Lord.
Oh yes, and you say this is under?
R. R.
Thank you.
Thank you, my Lord. Captain, is when the reference is made to the witness testimony at the State Capture Commission, is reference being made to this sworn statement?
Yes, according to the heading.
This is a 18-page document by Ms. Cholota that she testified to before the State Capture Commission of Inquiry, detailing her responses to the allegations in an affidavit by one Mr. Dukwana. Is that correct?
Yes, according to paragraph 8, yes.
Was this document before Ms. Cholota at any point during the interview at the Sheraton Hotel on the 22nd of September?
Presented to her or?
Presented to her.
We didn't take this one.
And so, apart from the fact that the interview was based on the sworn statement and the testimony, there was no such sworn statement and testimony before Ms. Cholota during the interview. Is that correct?
Well, as I said, we did not take this affidavit on.
And so, Captain, when the witness is having trouble recollecting certain facts or confirming certain facts on an unannounced interview with 5 officials, public officials from the US and South Africa. On what basis was she expected to recall this information?
On the basis that it was emails sent by herself.
And were any such emails before Ms. Cholota during the interview?
We presented emails, yes.
Were these emails... And so the investigators brought the emails that they wanted Ms. Cholota to confirm from South Africa, but they did not bring a copy of the sworn statement that she attested to before the Zondo Commission. Is that correct?
Well, yes.
Captain, where in the sworn statement is any reference made to the emails that were presented before Ms. Cholota? Could you kindly take us there?
Didn't go through the whole affidavit. The only paragraph that is mentioned about emails is paragraph 26. The duties and job responsibilities at the Office of the Premier involved but were not limited to. 26.2.
26.2. Dealing with correspondence, that one.
Yes.
Now, at the very top of the very paragraph that you've just pointed out, the affidavit references the Office of the Premier. Correct?
Yes.
And if my memory serves me correctly, in the evidence in chief, there was an annoyance with the fact that she kept referring to the Office of the Premier. Is that correct?
Yes, when we were asking her about in the email on instruction, which the email says on instruction of the Premier, that is what the question was based on. We want to know who she's talking about. Although we knew who was the Premier, we wanted to know, according to her, who gave her the instruction.
And she would respond, the Office of the Premier.
Yeah. Yes.
Captain, I put it to you that if a witness makes reference to the presidency and then the president, the presidency means the office of the president. Is that correct?
That's correct, yes.
And that the two are not one in the same thing. Is that correct?
Most probably, yes.
And an instruction could come from the presidency but not be attributable to the president. Is that correct?
Could be.
Now, in her affidavit, Ms. Cholota explained to the Zondo Commission and the chairperson of the Zondo Commission the makeup of the Office of the Premier. Are you familiar?
Excuse me. I'm still writing.
Are you familiar with the makeup of the Office of the Premier?
Well, I know there's a lot of personnel in this.
And so, if we are to accept that the Office of the Premier and the Premier are two distinct entities, why is there a problem with her attributing an instruction to the Office of the Premier?
But it doesn't say Office of the Premier. It says the Premier request.
Where does that state?
Where's the emails? Give me an email.
are we referring to the email? This is a hypothetical situation that I'm putting to you.
I'm talking about facts. I want the email, then I will show you.
Okay. Can we go back to this, the two different entities?
As a copy, my lord, my accused Magashule is present.
Where is he now? Good afternoon, sir. Please, next time if you want to go to meetings, you notify me before the time and you ask permission to do so, you understand?
Thank you.
Thank you, you may sit down. Thank you, sir. Thank you.
As a copy,
Thank you, my lord. I believe we were still busy with the office of the Premier and the Premier. Hypothetically, without sight of any emails, if there is an instruction that comes from the office of the Premier, does it necessarily follow that that instruction is from the Premier?
But I don't work on hypotheticals.
Then can we use the presidency as an example?
No.
Okay. Now, if we are to go back to the same HI, tab HI, again the Constitutional Court affidavit. This is at page 8. Paragraph 26. Page 8.
Is that the affidavit of Mr. Cholota?
That would be your affidavit, Captain. HI, the blue.
Oh, sorry. Yes.
Paragraph 26.
Yes.
If you could please read that into the record for us.
Later that afternoon, Brigadier Gerber and I made a telephonic contact with the prosecutor in the Asbestos project criminal matter Extradition, and informed him that, in our view, Mr. Cholota was not very cooperative and had shown irritation and frustration at many of our questions, especially when she was pushed for more details or further answers.
And what does that mean, that cooperative, when used in this context?
You are reading from what paragraph?
26.
That would be tab HI, my lord.
Yes, that's page 8.
Tab HI.
Yes.
Yes, page 8, paragraph 26.
Yes. Thank you.
Later that afternoon.
Just repeat for me, please.
If you could please reread it now that the judge has the...
Later that afternoon, Brigadier Gerber and I made a telephonic contact with the prosecutor in the Asbestos project criminal matter Extradition, and informed him that, in our view, Mr. Cholota was not very cooperative and had shown irritation and frustration at many of our questions, especially when she was pushed for more details or further answers.
And my question was, that not very cooperative in this context, what would it mean to be not cooperative?
Well, not answering questions that's very easy to answer.
In whose view? Ms. Cholota's or your own?
No, in general.
In general. And that she had shown irritation and frustration at many of our questions.
Yes.
Would it not be reasonable, Captain, to be irritated and frustrated at being asked about questions that pertain to oral testimony that you've given, that you're unprepared to answer? Would it be reasonable to be frustrated in that context?
Are we talking about the evidence before the commission?
The evidence before the commission, yes.
Well, it's two institutions, the Commission and the police.
Yes.
So if I ask the same questions, that's not a place to get irritated. It's two different institutions, if I can say.
Understood. However, we have just read into the record that you had informed her that you would be interviewing her on the basis of her testimony before the Zondo Commission. Is that not correct?
So that would be part of.
And so the questions that were being asked of her were in relation to the testimony before the Zondo Commission.
Well, let me answer like this. That I cannot be dictated on what questions to ask. These questions were asked at the Zondo Commission prior we identifying certain information. So we identified additional information through our investigation. So to leave that information alone and not ask her about it, we just can't do that.
Indeed, that makes sense, but I think I'm pointing to a different issue. Before you right now, I'm questioning you on your own evidence that you wrote before the Constitutional Court. But I have the courtesy of putting the affidavit before you so that you can reference the affidavit when I ask you specific questions about specific paragraphs. If I were to ask you about page 18 of this affidavit without you having had sight of it, would it not be reasonable for you to be frustrated and irritated?
No, I just wouldn't be able to answer you if I don't have it in front of me.
Indeed. And would that make you not cooperative?
No, I won't say that.
Would it be reasonable for you to be frustrated at that?
No,
It would be unreasonable for you to be frustrated at that.
I won't be frustrated.
You would be
Asking for the document they're talking about.
because you feel
Cool and calm.
cool and calm. Thank you, my lord. If we can hold paragraph 26 and paragraph 31 on the following page, and I'm focusing there on the last sentences of both these paragraphs. Are you there, my lord?
Yes, I'm also there.
The end of paragraph 26, especially when she was pushed for more details or further answers, and the end of paragraph 31, and regularly became frustrated when we pressed her to provide facts which had to have been within her knowledge. Pushed and pressed. What does it look like for a witness to be pushed and pressed?
The same answer being asked over and over and over again. They're not getting a response.
That would be pushing or the pressing.
Both.
So to push a witness is to ask the same question over and over and over again.
In different ways, yes.
And do you change your demeanor when you're pushing and pressing?
I have one demeanor.
Yes. And so in this instance, it would have been two of you having that demeanor, pushing and pressing.
I was conducting the interview.
And Brigadier Gerber?
Every now and then he would come in, but he wasn't the main person asking the questions.
He was simply there to intimidate. We will get to more affidavits where this pushing and pressing is mentioned, but for the purposes of this affidavit, could I simply ask, is this what is to be expected by witnesses, to be pushed and pressed? Or is it simply Ms. Cholota?
We ask questions to to each and every person who can assist in a criminal matter.
Are they also pushed?
Well, if you know, I do not interview a person. If most probably I do not know the answer already.
Interesting. Thank you, Captain. If we then have regard to the sequence of events, if I'm understanding it correctly, the 22nd was questioning, and the FBI officers were not in the room. It was the one FBI agent, 2 Hawks officials, and Ms. Cholota. That was the first day of questioning, correct? And was there anything said to Ms. Cholota regarding her uncooperativeness on that day?
Yes, I've been involved into it.
Could you take us into your confidence as to what was said to her?
Well, we gave her, as I said, we gave her basically advice. It would be in her best interest to seek legal advice. Because according to us, she's not giving her full cooperation, not answering the questions honestly. And we told her to get in contact with a legal representative of her choice to get some guidance. And if not, the same, or her demeanor are the same, we would not have any choice but to treat her as a suspect.
And did you tell the Constitutional Court of South Africa that in your affidavit? That you gave her, quote unquote, legal advice?
I didn't give her legal advice.
Perhaps I've misunderstood you.
No. Legal advice is something else. I told her it would be in her interest to get legal advice.
Okay. My question still stands. Did you tell this, what you're telling this court, to the Constitutional Court?
Where's my affidavit?
It's the one that would presently be served.
Is it this one?
Mm-hmm.
That I see here, no, I did not. But I did not go through the whole affidavit at this stage.
But on your preliminary glance of your affidavit, there's no way that you told the Constitutional Court what you were telling this court.
Well, that I told her it would be in her interest to get legal advice.
Yes.
No, on my first glance, no.
And did you tell the High Court this in the High Court affidavit, just off your own recollection, without having regard to your affidavit? You cannot recall. And what about the magistrate in the bail court? Did you tell her that you gave Ms. Cholota advice to seek legal advice?
Well, I don't know whether it came up, I can't remember.
If we turn to page 23 of the same affidavit under HI, page 23. Paragraph 86.6. We will be reading this into the record together with 86.9 on the following page. So that's 86.6 read together with 86.9. If you could please read those two paragraphs into the record, Kaptein.
Neither Brigadier Gerben nor I made any threats, admonished Ms. Cholota, or intimidated her. it is correct, however, that we told Ms. Cholota to think about the matter overnight, as a failure to cooperate may lead to us considering her to be a suspect. So, point 9.
86.9.
On the second day of the interview, it is correct that we informed Ms. Cholota that a refusal to cooperate by answering the questions we posed to her would lead to her being considered a suspect and warned accordingly. There is nothing threatening encompassed in such a statement. The questions we asked of Ms. Cholota were based on her own documents. There could not have been anything she honestly knew nothing of.
There is nothing threatening encompassed in such a statement. Threatening to whom? Or threatening according to whom?
Are we talking about now us warning her to be a suspect?
Yes, so it says that there's nothing threatening encompassed in such a statement. So warning her that her refusal to cooperate might lead to her being considered a suspect.
Well, it's not a threat, it's an actual fact.
Be that as it may, if someone tells me that they're going to punch me and they indeed punch me, that could also be argued as a threat, as a fact. But that's not what I think I'm getting at here. It says that there is nothing threatening encompassed in such a statement. Threatening according to whom? Yourself or Ms. Cholota?
Well, to myself.
To myself. And on 86.6, neither Brigadier Gerber nor I made any threats, admonished Ms. Cholota, or intimidated her. It is correct, however. However, it would be a qualifying statement to say, we don't deem that as threatening, but it is correct that we did tell her what we told her. Is that correct?
No, we did tell her. I'm not denying it.
And so what would be the purpose of telling a witness to consider a matter overnight and then to attach the proviso that her failure to cooperate may lead to us considering her to be a suspect? What would be the purpose of that statement?
Being honest.
What was it trying to elicit from her?
No, nothing. It's plain. If the person for which I have evidence is implicit in a commission of a crime, and that person doesn't give cooperation, I have two choices. So I gave her the choice then either work with us and tell us what she knows, or get advice and then we follow the other route, her being a suspect. So I basically gave her a decision.
And is this what the 90 witnesses in this matter can also expect? Being given this decision?
My Lord, if I may object at this junction with regards to the relevancies of the other 90 witnesses, we are dealing here specifically with issues of threatening of Ms. Cholota. The other witnesses cannot go that far, my Lord, with all due respect.
I don't think you have to answer that question. You may proceed, ma'am.
Then let me put it like this. Is this how you normally treat witnesses that you interview? No.
No, it depends on the witness.
But this is not how you normally treat witnesses.
Well, all I can say is depend on the witness.
And in this particular instance, this treatment was sufficient for Ms. Cholota?
Well, she created the circumstances.
She created the circumstances. Thank you, Captain. Now, fortunately, you in fact did tell the Constitutional Court the reason that you actually charged Ms. Cholota. In your evidence of in chief, the state's legal representative questioned you about what do you say about the fact that Ace Magashule, the reason she was charged was because of Ace Magashule. And if I can just go to your response. It was that is not correct. That was your response, that is not correct, that she was charged because of Ace Magashule. Do I recall your examination in chief to be correct, that when you were asked that question, you responded that is not correct?
In what forum was that?
It was his examination in chief, my lord. The
Where?
question here in this court, my lord.
Here in this court.
The question that was asked by my learned colleague for the state, that the defense alleges that the reason why Ms. Cholota was charged was because of Ace Magashule.
Oh yes, I recall, yes.
Yes, thank you, my lord. To which he responded, that is not correct.
That is correct, yes.
Is that correct?
No, so she wasn't charged because of Mr. Magashule.
Okay. Now, if we can please turn in the same affidavit to page 33, paragraph 133. If you could please read into the record paragraph 133.
The fact that Ms. Cholota did not contribute certain instructions to a former boss had the result that she was then treated as a suspect in relation to some of the same charges Mr. Magashule, a former boss, was facing.
Now, Captain, the two statements are at odds with each other. It cannot be not correct that what the defense states is correct, and then this is what you stated at paragraph 133.
Can you just rephrase that question to make it clear?
There is a discrepancy
Yes.
between the statement that the captain made in evidence of chief, that it was not correct that Ms. Cholota was charged because she would not implicate Ace Magashule, and what the captain has stated at paragraph 133 of the Constitutional Court affidavit to which he deposed to.
Well, maybe then you can simply put it to the witness by saying that from this paragraph, for instance, it is clear that this is the only reason you decided to charge him.
Thank you, my lord. From this paragraph, it is clear that the reason that Ms. Cholota was charged was because she did not attribute certain instructions to her former boss. Is that correct?
Well, if you read that paragraph, it seems so.
Now, thank you for that, Captain. Now, if I were to ask, why is the consequence of her not cooperating fraud, corruption, and money laundering charges? Why was she not declared a hostile witness or brought to this court and declared a recalcitrant witness? Why is the consequence charges?
My lord, I'm going to have to object at this stage, is that we are not in the process of needing evidence at this stage. We would not have those revenues available to us. There was no witness statement upon which we could have even brought her before court to testify. This is what this issue is all about, my lord, with all due respect.
My lord, my learned colleague for the state unfortunately misunderstands my question. The consequence of Ms. Cholota not cooperating, according to these facts and Captain's testimony, was charges. She was charged on money laundering, on corruption, and on fraud. The question is, why was that the consequence of not cooperating? That's the simple question.
The evidence was there.
The evidence was there.
Yes.
But when you questioned her, she was a witness.
Yeah.
But the evidence was there.
It's our decision how to handle evidence.
And I'm glad you bring that up, Captain, because in the same Constitutional Court affidavit, you quote a case about reasonable and probable cause. If I can just find it. That would be at page 16, my lord, Captain. 16 of HI, the same affidavit. Paragraph 55. If you could please read that paragraph into the record.
National Director of Public Prosecutions v. Zuma, 2009, SA 277, SCA. At paragraph 37, the Supreme Court of Appeals said as follows with regards to alleged political reasons for pursuing the prosecution. The prosecution is not wrongful merely because it is brought for an improper purpose. It will only be wrongful if, in addition, reasonable and probable grounds for prosecuting are absent, something not alleged by Mr. Zuma, and which in any event can only be determined once criminal proceedings have been concluded. The motive behind the prosecution is relevant because, as Schredner J.A. said in connection with arrests, the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. The same applies for prosecutions.
Thank you, Captain. So if we stick to that last paragraph of this paragraph, it says the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. The same applies to prosecutions. What is your understanding of that? My Lord, it seems the senior counsel would like to have a word with the witness.
My junior, I think she should object. It's totally irrelevant what he's objecting. What's relevant is a court.
Yes, well, I would think that is anyway something for argument.
My Lord, if I may perhaps remind the State what the reason for our trial within a trial is. It is that at all parts of this extradition, unlawfulness was inherent in the manner in which the State operated. He has just stated to us that the reason she was charged was because she would not attribute those instructions to Mr. Magashule. The paragraph he has just read says that that cannot be. There must be probable cause. And that is the only reason I'm putting this to this witness, because this is his affidavit and this is his own quotation.
Yes. Ms. Makopela, that may be so, but we must be mindful that, as far as I understand, this witness isn't a legal expert. He is not in the legal profession, so maybe it's unfair to read certain paragraphs to him coming from a judgment.
Thank you, my Lord.
It's in his affidavit.
Thank you, my Lord. We do note, however, that it is in his affidavit presented to the highest court in the land.
Yes, of course. That is why I say that is something that can certainly be argument on your behalf.
As the court pleases. Captain, are you aware of the right against self-incrimination?
Yes.
Could you please explain to us your understanding of the right?
Well, when you're implicit in the commission of a crime, and you would acknowledge that, basically, telling what you did being wrong.
Is it the police's duty to inform a witness that their evidence could be used against them?
Yeah.
Was Ms. Cholota informed of this?
When she was notified that she could be a suspect.
When she was notified that she could be a suspect, and when she was notified that she would be a witness?
Well, we were asking questions relating to the document, so we were willing to use that.
But was she told?
That she might implicate us.
That she has the right against self-incrimination, that anything she says in the interview could be held against her.
No, not during the interview.
And so she was not informed of that.
No.
But when she was charged as a suspect, then she was informed.
I don't really understand what you're asking. So, you say that when we charged her, or when I took the warning statement, not charge her, When I took the warning statement, I should have told her what would be the implication for her implicating herself.
No.
Am I correct to say that?
That is correct, Captain.
Okay, sorry. So please explain to me.
I think my question is, because you had stated that you did inform her that she has the right to remain silent
Yes.
when you took the warning statement,
Yes.
and that she could incriminate herself.
Yes.
But did you tell her that when she was a witness, that what she says in that interview could incriminate her?
No, we did not.
Why is that?
Because she was a state witness.
But you've just stated a couple of minutes ago that you always knew that she was complicit.
We had the evidence, yes, but it's our decision whether to charge it or not.
Is it not your duty to inform witnesses?
Not to say.
I put it to you, Captain Kalitz, that constitutionally, the police are obliged to inform a witness and an accused of their rights constitutionally, including the right against self-incrimination.
When you warn a witness for remaining silent as the warning statement, okay, you say now witness. We did not inform her when she was a state witness. That's it, because we asked regarding certain documentation.
Now, the state's legal representative handed in exhibit after exhibit from A to O this morning. Missing in those exhibits was your answering affidavit before the magistrate's court in bail. Is that correct?
Yes, it's one part of it.
What is the reason that that was excluded from the bundle?
There's no reason for that.
It's
There's
simply,
it's not part of this trial.
it's not part of this trial.
If you tell me what is part of it, well, then I can answer.
Okay. My Lord, I beg leave to hand up the captain's answering affidavit before Magistrate Dalanga in the bail proceedings August 2024 as tab S.
Is it the record of the bail proceedings?
It is not, my Lord. It is the affidavit of the state that was deposed to by the witness,
Oh, I
Captain
understand.
Kalitz.
I understand. Yes, thank you.
Thank you, my Lord. Captain, could you confirm that this is the affidavit you deposed to before the magistrate's court in August 2024?
It's an unsigned copy, so I need to go and read through it.
If I could please make a submission, my Lord.
Yes.
The affidavit was submitted to the defense unsigned at the bail proceedings. And so that is the copy that we have. If the state has a signed copy, which we were not furnished with, then could we ask the indulgence of the state to furnish us with a signed copy? However, it was unsigned. in August.
And it was handed in,
It was
served before
handed
the
in and
court.
accepted by the magistrate, my lord.
My lord, the copy that was submitted to the actual court was then signed. That is not then the copy that my learned colleague has. I believe it's the copy that was handed to my learned colleague, not the one that was formally handed into the court.
Yes, because that was the one that was signed.
Indeed so, my lord, for the court.
If I may proceed, my lord.
Yes, you may. But the witness hasn't confirmed yet that what you now placed before him was his affidavit.
He hasn't, my lord. He has not.
Yet. Give him a chance to look at the affidavit.
Thank you, my lord.
I wonder, maybe, Ms. McPherson, we could save time eventually if you could get hold of the signed affidavit. Is it possible?
It will be possible, my lord. It would be still with the record room of the magistrate's court. It should be possible. Filing can sometimes be an issue, but we will endeavour to do our best to locate the signed version.
You are reading through that affidavit now, Captain?
Yes, my lord, and as I go through it, it seems to be the one, yes.
Yes. Are you willing to accept this is the affidavit that you made?
Yes.
Thank you.
I believe you sped up the process.
Apart from this aspects, Ms. Makapela, are there also other issues, other aspects that you will be traversing with this witness?
Indeed, my lord. The sequence is as follows. After this line of questioning, we're going to move on to the fugitive from justice and evading justice line, which is in this affidavit, as well as in the Concord affidavit. We will then move on to the probable cause that was intimated to the United States government, on which their extradition was based, and then we will move on to the information that the U.S. sought from South Africa, where they stated they do not have factual basis for an extradition, and the information that was provided, and then we'll close off with some of the events that occurred after her extradition and why it is unlawful.
Yes, I'm only asking to make sure that my view is correct, that you will not finish your cross-examination today. It will certainly continue tomorrow.
Your view is correct, my lord.
Yes. I'm trying to, Ms. McPherson, I'm trying to get a feeling of how long we are going to be busy with a trial within a trial. Is it possible for you to give me an indication if the captain now in the witness stand is the only witness that you will be calling in the trial within a trial, or are there other witnesses that will also be called?
Well, it's very difficult to say at this juncture due to the fact we're not sure what further evidence will be elicited from the captain before.
I can understand that.
So it's a bit of a predicament to indicate, yes, definitely only this witness, or that we would require further.
It is unsure.
We do have further witnesses ready, my lord, if necessary.
Yes. I'm asking you because you might prove me wrong, but my feeling is we won't finish the trial within a trial this week. It will probably go into next week.
I would believe so, my lord. But how better guided by my learned colleague, she'll know how long she's going to take with regards to her cross-examination.
My lord, excuse me, my lord, may I also add, my lord, it's our intention also to apply to cross-examine this witness, because your lordship will note from our plea explanations and the triable issues of our clients that also impact on the testimony that's been dealt with in this trial within the trial. In particular, my lord, the paragraphs 2.2 and following of both of our plea explanations have been dealt with directly in this trial within the trial. I stood down because the trial within the trial was called by my learned friend, and I thought it only proper that she runs first. I do believe that other accused might also have questions for the captain pertaining from his evidence, but I wish to record so that you can work out the time that I'll be applying to do so also.
Yes, Mr. Houders, I think we can, if you make such an application to also cross-examination, we can certainly consider it.
Yes,
but I would prefer the trial within a trial to be focused on the simple question whether this court has jurisdiction to deal with the case of Ms. Cholota. And I will not easily allow the matter to go wider than that, because then we will be going into the merits of the case against other accused persons, which is outside the scope of the trial within a trial.
Not necessarily, my lord. On the one aspect, if I can just state this, that everyone can prepare, my lord. The one aspect that was raised on behalf of accused number 13 was the effect of making Ms. Cholota state witness against him, which was a defense witness, which in itself, and there's authority on this, my lord, points to prosecutorial irregularity. We made it clear, my lord, we raised it in our application before. We were told that this would be the correct forum to decide that issue, and that has been the subject matter of most of his testimony thus far, my lord. I cannot say whether it will go with absolute certainty, but it's quite clear from the correspondence that's before your lordship, in particular the emails that we weren't privy to prior to this application, as well as the affidavits that were handed to your lordship on behalf of the state, in that entire bundle without any further evidence being led on certain of them, that were placed before your lordship, it impacts directly on that very question that's raised, specifically and expressly by accused number 13, my lord.
Yes.
It's something to consider, my lord, and we will motivate a proper application for it, but I need to forewarn my learned friends that it's premised on documents that we didn't have previously that we've received now.
Yeah.
And there's been a duplication, my lord. Perhaps I can even direct your lordship's attention to this, because it might save some of the work, my lord. What my learned friend now has handed up is the emails between the prosecution and Regular Gerber were handed in by the state as well, my lord. I'll give your lordship the reference. The lordship will find these very emails, and I need to emphasize, my lord, that we've never had them for that. They're under bundle HR, my lord, towards the end. They're annexures to the affidavits that we had specifically requested. I can show your lordship, and we were denied access to on previous occasions, and that in itself would also indicate prosecutorial impropriety, which we are highlighting now, my lord, and will be the subject of cross-examination. Instead of having a multiplicity of trials within trials, my lord, it might burden the record at the moment, but in the long run, I believe it would save time. But that I place now so that my learned friends are aware of it, my lord.
Yes, thank you.
Thank you, my lord.
Sorry, my lord, one more issue. The state only disseminated copies of the application to those representing accused 3 and accused 17. I think from what Mr. Houders has brought to the court's attention, it should be only fair that any documents, whether the state believes they pertain to one accused only or a number of accused, be properly distributed to everyone. Because we're sitting in the dark, completely in the dark in some part of what is going on.
Yes, you.
And I've also raised the jurisdictional plea as well, my lord, so it may well be collateral issues.
Yes, thank you.
Thank you.
I was beginning to raise this issue of the further time frame of this trial within a trial, because I wanted to address counsel who asked that his client be excused while the trial within a trial is proceeding. So I think at this point, after hearing you, Ms. Makapela, I'm going to rule that your further cross-examination of the captain will continue tomorrow morning at 9:30 to give me time to sort out and to address the issue raised here of accused people being excused. Is that fine with you?
That is fine with
Will
me.
you be available tomorrow, Captain?
Yes.
Yes.
I'm always.
Yes, thank you. You raised, if I remember correctly, a question whether your client could be excused.
Yes, my lord. On behalf of accused 14 and 15, I received the instruction to make that request to the court.
No, that is a problem for me. They are out on bail. I cannot simply excuse people who are on bail in such vague terms. I will have to postpone their matter to a certain date and warn them to be present on that date.
I understand.
And warn them that they will probably be arrested if they don't pitch up again on that date. So I'm not inclined to grant any excuses for him to be present or for them to be present in court. I cannot do that. Can I just find out, are there any other counsel who will request permission from the court to cross-examine the captain now testifying in the trial within a trial, or is it only Mr. Houders?
Well, my lord, I'm not sure. But if we all have a copy of the application, perhaps we can better answer that question during the course of tomorrow or when the opportunity arises.
What application are you precisely referring to?
The trial within the trial proceedings. The bundle that the state provided was only disseminated to two people representing some of the accused.
Yes, that is Exhibit 9.
Indeed, my lord. So my point being, if documents are going to be referred to, they should be distributed to everybody. Because of the issue raised by Mr. Houders insofar as, well, he may well need to cross-examine. The same may apply to me, because my client has also raised the plea in 26 and 26.
Well, I'm sure if you make a request to the state that you may have insight into Exhibit 9, I can see no reason why they would deny you that opportunity. But in general, I cannot see why it is necessary for the state to make many copies of Exhibit 9, because all accused, majority of the accused, are not involved in the issue of this trial within a trial. Thank you.
My lord, I can also confirm that any of my learned colleagues that had requested the same have already been provided with both Exhibit 8 and 9 as per the request.
Thank you. I've already said that your cross-examination can continue then tomorrow 9:30.
Indeed, my lord.
You did indicate to me that you are now going to move on to another aspect.
We'll only deal with the intimation. Sorry, my lord, I've lost my train of thought.
Yes, you lost.
The train of thought was only in regards to the cooperation element. and we were only going to be dealing with that point that is in the opposed bail affidavit.
Yes,
And then tomorrow
you were busy to introduce the issues in his answering affidavit in the bail application.
In the bail application. My Lord.
And you are happy to do that tomorrow.
Thank you, my Lord.
Thank
As
you.
the
The
court
court will
pleases.
then adjourn till tomorrow 9:30. The accused are all warned to be present. The bail is extended till tomorrow.
Yeah.